Prior to this, you had filed OA number 708.
Yes.
That order has already decided the issue. Then why have you filed again?
Because, sir, already on the previous occasion, this High Court division bench ordered in favor of me. There is no need for residence. But the respondents did not obey that order. And earlier on another case, another occasion, the same order was passed. This division bench in this court. And besides, the Supreme Court has the order, many orders.
Then you
The
did
residence not required.
you did not move for contempt.
I-
If the High Court division bench passed order in your favor, you for executing that order, you did
I wanted clarification with the for the RTI application and RTI application.
What RTI? You said the High Court division bench has passed order in your favor.
Yes.
Then why you went to the tribunal again?
Going to tribunal.
Why? If the High Court has already passed, a division bench has passed order in your favor, then why did you file OA 708 again?
Sir, new evidence I got. Again, a new evidence got.
Sir, once you say that the division bench has passed order in your favor, then where is the question of new evidence? You should have gone and joined.
But the response I made representation, I made I go into the CAT, but they did not obey. What should I do?
Just now you said that High Court has already passed order in your favor.
Yes, sir.
If High Court has passed order in your favor, why you will go to CAT again and again and High Court again? Once the order has been passed in your favor, you should have joined. And if they are not allowing to join, you should have filed contempt. Why you are moving the court again and again? We are unable to understand. That's why we are asking you.
I did not make contempt application, but I request.
Where is the order of the High Court that you should be appointed? Show us division
150.
Please wait.
Sir, page number 1444.
How it is in your favor? Read paragraph 9 of that judgment. How you are saying it is in your favor? Read paragraph 9.
Because first.
Read paragraph 9 of that order, sir.
After having heard the learned.
Read paragraph 9 at page 149. Read paragraph 9 at page 149.
149, 144, sir.
Yes, 144 ends at 149. Read 149. Paragraph 9. One 44 was only to pass a speaking order. Thereafter, after a speaking order is passed, you have gone to the tribunal. So 144 is not in your favor. That is just to pass a
What
speaking
for
order.
High Court judgment, sir?
That is for passing a speaking order. What do you mean in your favor? That's not in your favor. That's just to pass a speaking order. So that is not a correct submission when you are saying that's not correct. There is no direction that you have to be appointed irrespective of whether
Consider my case with the High
it is
Court.
not in your favor. That they will consider, they can reject, they can accept. That's not in your favor. That's just for consideration. Don't say it is in your favor. Consideration does not mean it has to be positive consideration. Consideration can be negative also.
Yeah, I want to say another thing. Sir,
So that is no order in your favor.
consider this rule applied when I was.
Then you went to CAT. CAT has also passed the order, which has page 149.
149.
In 2008 itself. So this order of the CAT, WPCT 50, did you challenge it?
Yes. Yes, sir.
Sorry. What is the order of the CAT is passed in OA number 50. OA number 341 of 2009. Then that was writ petition was rejected, dismissed. Then, then after that, what did you do? After WPCT 320, then what did you do? You filed a representation again.
RTI application. RTI application, and then I got many appointment letter of many same cases candidate from all over India, from all of the postal circles, and got the appointment has said that there was no need, there was no need to the residence for any employment.
You cannot move for the same relief whenever you want. The court is not meant for repeatedly raising the same issue which is already decided. You cannot do this. This is not permissible.
But what is my fault, sir?
See, unfortunately, we are not here in to advise you or to reply what is your fault. When the court has considered your matter twice, thrice, every time it has been held that you are not entitled, then after that you cannot file a representation and then file another case. You cannot file RTI and file another case. You cannot do that. That's not permissible. Once the matter has been decided, either you have to accept it or you have to go before the higher forum. You cannot move in circles. The court is there to consider your case. It has considered it twice. And again you have filed. So this is unwanted litigation. This is pointless litigation. You will get nothing in this. You understand, you are saying that I have got other document under RTI or whatever. But the order is, there is a method and there is a remedy for everything. That does not give you permission to file again and again and again for
But sir, residence qualification is not needed for my employment.
that you have said twice, twice to the CAT, twice to the High Court already. So now this is the third time when you have gone to the CAT. Now you are before the High Court on the third occasion. If we dismiss it, again you will file before the CAT, again you will file before the High Court. So you cannot do this. This is not permissible. Once it has been decided, either you have to accept that yes, this is my fate, or you have to go before the higher court. You cannot do this. This is not permissible. So
Sir,
the CAT's order is only that whether again you can file for the same relief. So they are correct. They are saying you cannot do this.
Sir, before Honorable Chakrabarti and Parthasarathi Chatterjee also asked them to give me the appointment.
Show an order that
Because the residence is not the
show an order, any order that they had directed to give you appointment. Any order. And if there was an order, then you should have got it
Yes, sir.
complied. Then where is the question of again going to CAT?
Yes, sir. No appointment order was given.
No, you said that the bench directed them to give you order. Where is that direction?
No, oral instruction given.
Don't say.
Oral instruction.
Don't say that. Don't say that. You cannot say that. What we finally record in the order sheet is the order. This is not permissible. The cat is correct. We have been doing this for a long time now. My God, the first writ petition of 98.
98.
What is the advertisement date?
But, but 22/5/98. 22/5, 22/5/98.
22/5,
98.
98.
Sir, I got two appointment letters. Sir, 8/5/98. Eight six eight. 868.
of 98. Where is the order passed in WP 16307 of 98?
The order was passed on 16 April 2007.
Which page?
On which way 137, sir.
That is the first case that you filed.
Yes, sir.
137, page 137. No, this is not the first case. Before this also you have filed OA.
Before this, I made application only.
No, before this you filed an OA.
No, made application.
Please come to page 40, paragraph 6 of that order.
Yes, sir. There is such mention, and I only wrote to the register that registers.
But you did not file any application.
No.
And this order was challenged by you.
Yes, sir.
This was challenged in which proceeding? 320 of 2000? No.
50 to 2000, page number 141, sir. Page number 141.
141. Hmm.
Yes,
Then you have filed a WPCT 50 of 2008,
2008.
OA number 341 of 2009,
Right.
WPCT 320 of 2012.
2012.
Again representation, then again OA 708 of 2017.
Yes.
That was also dismissed. 708 was dismissed. So 708 order, did you challenge in before the High Court? No.
No.
Then again you made representation, again filed away.
Then I made RTI application.
Whatever, RTI representation, whatever, yes.
RTI application, with the RTI application, I made the last way.
So this is the 7th petition or application invoking the court's jurisdiction.
Sir, after WPCT 50 to 2008, the way number one, page number 140,
OA 341.
341, first, see the first para. Yeah, the CAT ordered, CAT observed, or not ordered, observed that after appointment I should take residence. The first para written, and High Court also said the same thing. But 2012, High Court also said the same thing. Observation, I am saying the observation, but the court was misled. By fraudulence they won the cases, and I defeated the case every time. I am the victim of fraud. Court was also the victim of fraud. They won the cases by fraudulence. There are many evidence.
Where is the order asking you to join? Where is the order declaring the result at the initial stage? Where is that order? They must have given you some order that you take up residence in the local village. Where is that order issued by the authority directing you to take up the residence in that village?
Yes, sir.
Page 135.
Please let him show. We'll hear you.
134 to 136, sir. Sir, page number 135 and 135A.
This was based only on interview.
Yes, sir.
Interview was done on 8th of May.
8th of May. Sir, interview and biodata verification was done at 22 March 98. 85 give me the intimate me with the letter that I should appear on the interview date.
On which date?
22/5/98.
22/5.
98. 22/5.
Where is the published any result on that day, on 22/5?
No, sir, communicated me after that on 28/5/98 I was intimated with the letter, the result. Yeah, I was eligible for the post.
So they gave you 15 days. That is what we are
Yes,
saying,
yes.
for taking up the residence. Then why did you not take up the residence?
I made representation to the SPO that I could within only the short period I could not get the residence, and I also submitted the residence certificate before you on the interview date. Which certificate? Bhatpara municipality certificate, residence certificate, chairman of the Bhatpara municipality. I already given to the interview authority.
No. They asked you to take up residence at Jagat Dal PO.
Yes.
Why did you not take up the residence at Jagat
Because the
Dal?
time was very much short, sir. Only 15 days.
But the person who was third impaneled, he immediately got the residence.
I don't know because the rules does not say so. Postal rule does not say so that there should be required the residence. It was illegal demand of the SPO that I should take up the residence, but the postal rule does not say so. And many judgments say so, same thing. There is no need for three because there are many judgments.
When they wrote to you on 28/5/98 that you take up residence, did you tell them that I will not do this?
I made representation.
What did you say in your representation?
I made a representation with the request that with the request and with the complaint that it was very illegal. And
where is that? Let us see. Where is that representation? You were required to take up residence by 12th June as per this communication, because they granted you 15 days. So when did you tell them that this is illegal, I will not do this?
sir, all the files. I'm seeking here.
Show from the file. We are not going to accept any document like that. You said that
This is the
no. Where it is from the file? Show from the file. In your OA, you must have said the first writ petition that you filed that I have told them that this is not required. Where have you said this in the OA? There is nothing to show that you objected to this. They granted you 15 days time. You did not come out with a address for the concerned post office. But there is nothing to show that you said that this demand is illegal. Where is this? Show us.
Sir, in the writ petition, there is the representative is not here.
Then how anybody will know that you did this?
Because they replied of my representation. Upon the replied.
Where is that show? Where is that?
In the writ petition? In the writ petition, I mentioned, but there is no attachment is not here.
No. In the first writ petition that you filed, the first one that you filed.
Yes.
Where have you said in that?
Writ petition.
Yes, first you filed WP 16307.
Yes.
In that you said that I have told them that this is not required.
Representation, sir. Representation. I represent. And
in the writ petition, did you mention that representation about that representation?
Every representation I mentioned that.
In WP 16307.
Every
where is WP 16307?
There are many, sir. WP here is the not writ petition is not here.
Yeah,
first revision.
see, in between 28.5, in between 28.598 to 12.698. This is the time you had for giving a residence certificate. You had been granted 15 days. So therefore, from 28.5, you had time until 12.6, 15 days. In between 28.5 and 12.6, did you tell them that this requirement I am not going to fulfill because this is not required?
Yes.
Where is that?
Sir, I was in the petition, in this petition, not there, but here is the here is the representation. I took
Cannot be.
and
Cannot.
they replied to my representation.
To show from the file, where is the reply?
Sir, I mentioned here, but the attachment was not.
Where is that mentioning? Give, show where it has been.
Index.
No, index is not petition.
Oh,
Index is not petition.
all right, all right. I'm showing. I am. Sir, page number 4, sir. Page number 4C. Read petition, page number 4C.
No, but then this statement, you have not made any statement that you have told them that this is not required. You are saying you have sent representation to allow you to join the post, and also the petitioner repeatedly reminded the SPM. You have not said that I have told them that this is not required. This is a
Illegality. I said illegality.
Where is that?
The next line, the page number 5.
Yes.
Page number 5, the first para.
C. You are referring to C.
Yes, sir.
The petitioner requested the SPM by visiting his office and then by sending representation by registered post to allow the petitioner to join, and also the petitioner repeatedly reminded the SPM of his illegality of disallowing the petitioner. You are not saying that this is not required. You have not said that this is not required. Just because he is not allowing you to join, that does not become illegal.
In the representation, I told that within the short period I could not afford that residence.
Correct. That you have said within a short period I cannot do it.
Yes.
But have you said I am not going to do it because it is not required? That we are asking you. Have you said that I will not do it?
Understood. But I mentioned many times with the many letters.
Yeah, again, we are asking you, within the 15 days, did you tell them
yes,
that this is not required? That you have only said this, I don't have, give me some more time. You have not said that this is not.
No, they replied that they did not give me time.
What they said, we are not asking you. We are asking you what you have said. You have only said that I can't do it in this short time.
Yes.
This is all. You have not said that I will not do it because it is not required. That you have not said.
I cannot recall, but this is the.
What do you mean you cannot recall? You have written it. Nobody else is there to say, but you are the only person.
I can read, sir, a representation. Yeah. No. This is the representation. I can read what I said.
Even if you have
after 25 years.
Even if you have no, that is why 25 years, 7 petition and application you have filed.
Because I am defeated by fraudulence. Because I am defeated by fraudulence. They are lying. They are perjury. Committed perjury. What should I do? I I cannot afford, sir, go to the Supreme Court. I have no money, sir.
No, you have filed so many cases. It seems you have sufficient funds. Otherwise, how you can file repeatedly?
No,
7 times you have filed. Therefore, we are discussing that you are not short of funds. If you were short of funds, you would not have been doing this.
sir. I am doing only tuition.
But sir,
What? How
we are,
can I get so much money?
we don't know, but we are only to gather what you are doing. This is seventh
20,
occasion.
25 years I am wearing this pant and the trousers and shirts.
But you have to realize the limitation. There is a limitation in the system.
Trousers have been wired out. I am victim of fraud by fraudulence. Supreme Court has also said, every time said, and on many judgments, many CAT judgments, many High Court judgments, there is no required residence. They did every time they go to court and for every applicant, and they took their judgment in their favors. Same issue, residence issue. And Article 162 said that there is no record in the residence for any employee, for any of public employment. They do not obey that article. They do not obey Constitution. They do not obey High Court. They do not obey Supreme Court. And I am a little man. What should I do? $25 gone, lost, my blood lost. They exploited my blood. I wrote many times. I wrote Supreme Court. I wrote Supreme Court. I wrote every judge.
Where is the rule? Show us the rule.
Yes, sir.
And which judgment says that it is not required?
I gave you, sir, and on an earlier day I gave you the Supreme Court judge.
Yashoda.
So yes. And residential requirement is mentioned in the petition.
Where is the judgment? You are saying that High Court, Supreme Court has various times said that residence is not required for this extra departmental
Yes,
post.
yes.
Show us one judgment.
In the petition, see. On the earlier date, I said the same thing. Sir, page number, sir, 58. This court's judgment and residential observation, 50.
No, this is not Supreme Court. No, this is Calcutta High Court.
Mentioned there is Supreme Court, sir. Sir, page number 65. There is mention of Supreme Court.
65.
Yes, sir. In this judgment, there is mention. High Court judgment, Calcutta High Court judgment. There are many other Supreme Court judgments with me.
No, there is in your case, the requirement is under Rule 4.
Yes.
Regarding Rule 4,
yes.
Is there any judgment that as per that rule, nobody is required to take up the residence?
There is no Supreme Court judgment. There is Central Administrative Defense Central Administrative judgment. I gave you, sir, in the petition.
Rule 4.3.
4.3. Rule 4.3.
Where is the Rule 4.3? Is it in the writ petition?
Yes.
Where is at which page?
Sir, page number 217. Page number 217, 45 page judgment, Central Administrative Tribunal, Mumbai. Five times repeated, there is rule 43. Total residence rule.
Rule 4.3, not 43.
Rule total, there is rule 4, there is the 3 part. This judgment said that no requirement for such post for residence requirement not.
Where is it? In which paragraph? Sure.
Sir, page number last page, there are 5 times repetition. 258, sir. So see the page number 25, 258, 258, sir. No, sir, 257, 257, sir. 258, not 257.
Yes, we'll read. Don't worry. That is all.
No, sir, if you ask me any question, I'm ready to answer.
What else? What else you want to tell us? We have seen the judgment of CAT.
And for my my post, for my post, page C 268,
268.
268.
So this
It is-
CAT judgment was not for your post.
Yes, sir.
This CAT judgment was for GDS agent.
Same thing. GDS the
You applied for which post?
SV at a extra departmental stamp vendor. This is the GDS Gramin Dak Sevak stamp vendor, sir. Same thing, sir.
Which page?
268 for the same post for which I applied. I was selected.
268.
268 it clearly states that no requirement residence for the same post, EDSB.
Two six eight. What is?
Page number, sir, 268.
Yes.
268, sir, third line, sir. As the law stands. Third line, as the law stands.
Yes. All right. Anything else?
Sir, I made many prayers, sir, and following the Supreme Court, High Court, and CAT judgment.
No,
and
no.
rules.
We are not asking prayers. These two judgments, both are of CAT.
Yes.
Both these judgments you have shown.
Yes.
According to you, as per these judgments, they cannot ask you to take up residence within the jurisdiction of the local PO.
Yes.
Any other judgment on this point?
Yes. There are many judgments. The page number. Sir, page number 260, page number 260, para number 5, page number 260, para number 5, and page number 264, last para. Page number 260, para number 5.
Yes.
And page number 264, last para.
Yes.
Page number 74,
274.
only 74. At Calcutta bench.
Which paragraph?
Sir, coming later, sir, page C, page number 67C. 67, para number 3.
You said 74.
Coming later, sir.
Page?
First C, 67. First C, page number 67. Please.
Yes.
The department, page number 67, para number 3, the department admits that there is no requirement.
Page 67, para 3.
Para 3, sir. Department admits that there is no requirement of residence before appointment.
No, that is why we asked you. There is no requirement before appointment. But when they asked you to take up the residence within 15 days, then why did you not? That is why we asked you at the beginning. They have not said that because you are not resident of Jagattal, therefore you will not be appointed. They said, all right, you are number one. You take up residence, then you refuse. Why did you refuse? They are not insisting that because you don't have residence before, therefore you will be ousted. That is not their case.
Because, sir, I said within short period I could not appoint.
That is then is there any discretion available in the authority to give you whatever time you want? If you cannot take up the residence for 3 months, should they wait for 3 months? We are trying to see because we are hearing you. We don't want that after this also you should say that because of something which they have said. We are asking you, before appointment not required. They are also not disputing. They will not say that you could not apply because you are not residents of Jagattal. You applied, you were considered, you were interviewed, they asked you to take up residence within 15 days. You say, I cannot do it in such a short time. So therefore, if you can't do it maybe in 2 months, 3 months, 6 months, are they expected to wait? They have to put the extra departmental stamp vendor there immediately for the public of the local police post office. So they have to proceed. They can't give you any further time. Is there any provision in it is not a statute, it is some government notification which governs the appointment. So is there any provision in the notification that you could have got whatever time you required for acquiring a residence? They have to wait till you get your residence. Is there any provision?
No, but sir, the provision they made in the advertisement there was illegal, not in the rule.
Very well. Yes, that's all. Anything else?
Sir, you told me that within shortened period, I requested the appointment authority, but the appointment authority did not comply with my request. They refused my request.
No, you told us. We have understood. You have already told us that you told them that I cannot do it so soon. I need some more time. So therefore, we are asking you, how much time do you expect them to wait? How much time? And where is the provision that once a person has been declared eligible, until that person can acquire the residence, they should keep waiting? Can they do so? Is there any provision? Therefore, we are asking. Or they have to proceed with the appointment to the next person or third person or fourth person in the merit, so that as soon as possible they can appoint an extra departmental stamp vendor within the jurisdiction of the post office. Their concern is not to give you appointment. Their concern is to establish an extra departmental stamp vendor. That is their prime concern. For that, they have to comply with constitutional provisions. They have to bring an advertisement. They have to evaluate the inter se merit. All of this, you say there is no problem because you were declared as number one. Then they said that you acquire a residence within 15 days. Then you say, no, this I cannot do in 15 days. You have to wait. So therefore, whether at this point they are obliged to wait or they are obliged to take a step so that immediately stamp vendor can be provided for the public residing in the PO. These are the two things which have to be seen.
So there are another thing. They made two notification on different provision. Made two advertisement, but different condition
That is a different
on the
thing.
same date.
That is a different thing. That is a different thing. That is a different thing. You did not complain that, look, both advertisement is different because you were number one. Till then, you did not complain anything. Only when you could not take up the residence within 15 days, then you are looking for all these things. What is difference in that advertisement? What is difference in this advertisement? You could have said that I will not. Why have you published two different kind of advertisement? You did not say. You applied, you participated, you were declared the first person. Yes. What is it? He is relying on these judgments of the cat. What do you have to say?
Because on merit,
Where is the provision? We have yet to see the provision. Where is the provision? Where is 4.3 under which this requirement is there?
you'll have to kindly come to page 153.
153. Oh, this is 4.3. Yes.
Because 4 is the residence. Must be a permanent residence in the village where the post office is located. He should be able to attend to the post office work as required in view the time of receipt, dispatch, and delivery of mails which need not be adapted with convenience or his mail station.
So this is a requirement which the court has interpreted that although they are required to be resident, but applicant need not be a resident. Applicant be from anywhere, but after he is selected or he is offered the appointment, he has to acquire with it.
Comply with this requirement. And in the case, my lord,
But this does not give any discretion that you can extend the period for acquiring. There is no such provision.
instruction from the department that was not there. And because he failed, the number 2 was given appointment, he didn't accept the post.
Number 2 didn't accept, number 3 accepted, then he also left, and then you have advertised afresh.
The appointment
Those
was-
facts we have already seen, therefore we have not asked him anything on those.
that is the position. My understanding is relying on some judgments. All of them say that candidature cannot be
Correct.
refused.
He is also saying, he is saying that after selection, he should have been given some more time. That is what he is saying. Not saying. Think. That is all. Anything else?
Sir,
Another point
sir,
Yes. Another point?
which comes up, whether this question of merit can be reopened, that is
No, that's not the other point. That is the first point.
the point. my lord.
We have heard that. We are trying to consider the other point. Therefore, we asked you
My lord.
that if it appears that there is some injustice, whether when we are exercising jurisdiction under 226, but the rule is
There
clear.
no power to wait for an indefinite period of time, though no.
There is no scope for
there is
giving
no
him
scope
any.
for that.
so what is my fault, sir?
Hmm?
What is my fault?
All right. Yes, take down. We are sorry, we cannot help you. Yes.
So there are just cases where similar situated persons who to do appointment without residence. Sir. There are many cases that, sir. So please. Many similar situated persons, sir.
Item number 2.
Milord, I am for the petition. It is that matter, Milord, the pay some. Rafiq Masi case was considered. In view of the Rafiq Masi case, Milord, I have disputed some 1 point, Milord.
Yes.
The Rafiq Masi case means I have brought the Rafiq Masi case. Rafiq Masi case means was considered. The Saibram
5 conditions therein.
4 and 5,
Yes.
all the matter has been considered. But only question, Milord, everywhere it is stated, Milord, if there is no misrepresentation or fraud on the part of Milord, the recovery cannot be.
Yes.
That is the part.
That
Even
is- that,
but here in
that is from Sahib Ram's
Sahib
case.
Ram case, Milord, that I have just stated. All the matter has been decided.
You have come with
Ram,
Sahib Ram.
yes.
Sahib
That
Ram is the lead case.
lead case, that is the
Yes.
first initial
First
Milord,
case.
recovery part.
Yes.
Then Milord, on the in virtue or by virtue of the Sahib Ram, Milord, we have
All this
all
is
the case, Milord, we have
yes.
tried our best to consider that part, Milord, and series of matter was heard.
Yes.
And subsequently, Milord, then Milord, your Lordship will kindly consider, Milord, that subsequently after Sahib Ram and Abdul Qadir, all the matter. In the meantime, Milord, your Lordship will see the one matter.
So let us just see what is the fact in this. First, let us just see what is the facts. Just give us a minute.
Only, Milord, during the pendency, Milord, Chandi Prasad Union, your Lordship knows. That part also decided. That cannot be recovered. But Chandigarh, Milord, stated, Milord, that consider the Sahib Ram and Abdul Qadir, all the matter, Milord. That
No, just let us see the facts of this case.
Right.
Just give us one.
রাখুন পরে বলবো জাজমেন্ট মিলর একটা দেনা চন্ডিলাল দাঁড়িয়ে আছিস চন্ডিলালটা বার করে দে ওটা রেখেছিস দুটোতে একটা জজ সাহেবকে দুটো দে না জজের আর একটা কোথায় বইটার সামনে আর একটা সাথে তো কেসটা করে দে প্রত্যেক মাসে কেস কোথায় গেল
What is annexure RA by 2? Where is RA by 2?
Yes. Excuse me, one. Page 76 to 1. 76.
'76 is no, something else.
Yes. That is the RA Milord.
RA by 2.
RA number.
No. Annexure RA by -2.
দেখছি কোথায় হলো
This is arising out of review. Why you have filed a review for rehearing of the matter? You have challenged a separate, the OA separately.
Yes. Review application was filed, that review was also after passing the judgment, review application was passed.
So how you can invoke the review jurisdiction for rehearing of the matter? You cannot. The order passed, what did you assail the order passed in OA?
OA, the OA was not the order passed by the tribunal. The authority was not satisfied by the advice of the planet.
No, that we have understood, but therefore we are asking you, have you assailed the order passed in OA?
OA, if we assail the order of the OA, then we have to file the writ
So
application.
you assail the order passed in OA. This we don't want to encourage. This rehearing of the OA business. This we don't want to encourage. You are saying he has decided wrongly. What is it? Just an attempt to rehear the matter.
We normally the review application usually there's some documents were not placed and that was not. I do not know why I am not placing that. I am not supporting this.
But this is
But
arising
only
out of.
question we are.
But this is arising out of review. Why should we? What is wrong? The court has said that yes, you cannot go ask us to rehear. That is all. So you assail the order passed in the OA. That liberty will give you. You file away.
Only question if you consider your lordship consider the
No, we
way
don't want to encourage. We don't want. We don't want to encourage such thing. This is not the review jurisdiction is not meant for this. You know very well.
Yes, that's at the very outset that I am saying the review is not. But the original, if we assail the question of the original judgment of the OA application, that can be approached before the higher forum. But by any means, the RA was filed. The RA কেন করে দিতে বুঝতেই পারি না ফট করে আমরাই শুনবো এখানে
OA is also assailed in the same proceeding. The
OA
order passed in OA has also been challenged.
Yes.
Oh.
No, I am adopting the submission made in by OA affidavit in opposition that is in reply. If we place the reply, your lordship will kindly what?
Let us see.
Yes.
RA by 2. Where is RA by 2?
RA by 2.
Annexure RA by 2 to your reply. What is that page number? Can you give us?
Page 6. দেখেছি ওটা হচ্ছে না রিভিউ ওটা হবে না রিভিউ জাজমেন্ট ওয়ে অ্যাপ্লিকেশন জাজমেন্ট রিপ্লাই ওয়ে 57 ওটা কিন্তু আমরা কালাগালি খাবো আরে ভাই টুটা কোথায় গেল রে
Rejected the review. Now, therefore, I think that it's given.
আরে টু কোনটা ওটা তো আরে টু কোনটা আমরা বলেছি কোন জায়গায়
Yes. Where is RA by 2?
That I do not find RA by 2 I am some.
You have it
RA by 2
because that is your sheet anchor. That as per RA by 2, he was conscious of his fixation, still he has remained silent. And RA by 2 is not there. You place it on record. At the very outset,
RA by 2
we have asked the learned counsel for the respondent
appearing in this matter, my lord. He is busy in court number 17, my lord. My lord, I am praying for 2 weeks of adjournment due to service has not completed yet.
Not required, no service required. You proceed. Cannot be adjourned every day,
My lord, I'm praying for short Passover, my lord.
not today.
My lord.
Item number 4.
I am for the petition in this matter, my lord. Well, this matter, my lord, requires, my lord, for consideration. First is, my lord, whether a single bench can pass, my lord, the matter on merit by the tribunal or not. Second thing, my lord, our rule says that in the case of, my lord, excess payment, we can, my lord, recover that amount which is not under challenge before the tribunal, though the Rofik Masi was, my lord, considered. And fourth thing, my lord, your lordship is absolutely correct. I have also, my lord, advised them not to file, my lord, the review. Yes, your lordship is absolutely yes, my lord. As a matter of routine, my lord, they are filing. I also advise them not to. My lord, certainly, my lord. Certainly, my lord. Yes, very good. And my lord, in respect of the another point, that is, my lord, the 0.5% was deducted from the retail dues, which is not undue, my lord, as per the 5%. That is, my lord, your lordship knows, my lord, 5 category.
He is working
As my lord, class 3 and 4. There is a, my lord, confusion whether no, I will set your, my lord, lordship, my lord, the amount which we have, my lord, deducted, and which was the payment made to him.
Yes.
If your lordship kindly come. The amount paid to him, I have categorically stated in paragraph 10. He was supposed to, my lord, receive amounting to rupees 38,700,265, and we have already, my lord, deducted 2,43,293 rupees. This is not the undue, my lord. My lord,
All
page
con-
82.
All conditions stipulated in Rafiq Mashi
Well, page 82.
are complied by the.
But that is the view of the tribunal. That is under challenge before your lordships. All
That is
conditions are.
our view.
No, my lord, if
That
your
is
lordship,
our prima facie view which we are telling you.
my lord, if your lordship kindly see, my lord, my lord, page 82.
What is at page 82? Why
82
should we see? What is it?
Our rule says that is not under challenge before the, my lord, tribunal,
Yes.
and that is also not been considered by the tribunal.
Yes.
And Rafiq Mashi's case was also not considered by this rule. Our rule says, my lord, in a case of wrong payment and, my lord, excess payment, if it is not entitled by the persons, my lord, it has to be, my lord, recovered from the retiral dues.
Yes.
And that is not under challenge.
Page 82.
Page 82, my lord.
This was before the tribunal.
Yes,
This was before the tribunal.
yes. We have argued.
Which provision?
Page 82, if your lordships kindly come. 109, my lord. When any overpayments are made to the railway servants, these are generally recovered in installment with a view to mitigating hardship to them. In case of railway servants due to the retire on account of superannuations, the recoveries of overpayments should be spread in such a manner that the recountment in full is made within the period available in case
This
whether.
has not been considered by Rafiq Mashi.
No.
You are
Our-
reading which provision?
1019, my lord, page 82.
You don't want to read 1016.
1016 is also, my lord.
So read 1016
My lord.
before you read 1019.
My lord. Recovery of overpayments made to the railway servants by the drawing and disbursing officers may be waived only after the strictest possible scrutiny and only if there is a fullest justification for such waiver, which should be placed on record. So we have not.
Please read
My
it.
lord, my lord. Normally, no recoverable overpayment should be waived, but waiver may be justified if overpayment has occurred over a long period of time and the amount involved is very large compared and where it would be required many years to recover the amount. It may be held that by gripping the resources of the comparatively low
So
paid.
this has not been considered by Rafiq Mashi, but all conditions of Rafiq Mashi has been considered by the rule.
But the clause 5 of the, my lord, Rafiq Masi, my lord, in a case of undue hardship, here, my lord, 2 lakh and something has been, my lord.
It is no hardship.
That is not the hardship, my lord.
Very,
And
very unique submission being made by state welfare employer that for a class 3, class 4 employee who is retiring with 30 odd lakh rupees,
38 lakh.
if we recover 3 lakh, that will not cause any hardship.
Well, below 3 lakhs, my lord.
That will not cause any
And
hardship.
it is not his case.
And for that reason only the Rafiq Mashi should be not applicable to this case.
And my lord, in this case, my lord, it is not his case that, my lord,
Sorry.
the amount was paid to him lawfully. And another submission, my lord, if your lordship kindly, my lord, see the special bench judgment. Well, the similar, my lord, point was decided by the special bench of this honorable court. My lord, judgment was, my lord, written by my lord Justice Bhattacharya, my lord. If you lordship kindly see. Against me, my lord, this judgment. Still I am showing, my lord.
What a special bench will not prevail over the Rafiq Mashi judgment, sir.
No. A special bench against me, my lord.
Yes.
And, my lord, the argument which I, my lord, would like to, my lord, advance before lordships, that has also been, my lord, considered in the special bench. And, my lord, special bench judgment, my lord, followed by the Rafiq Masis and authored by, my lord, Justice, my lord, Bhattacharya. And against this order, my lord, we. Yes, my lord.
Yes.
Kindly see, and against this order, my lord, we preferred SLP, and that is, my lord, under consideration by the Honorable Supreme.
Maybe you get it considered. Who is stopping you? You get it considered. Nobody is stopping.
Matter is seasoned before the Honorable Supreme Court on the same point.
Get it decided.
My
Nobody
lord,
is
kindly
stopping.
see, my lord, the order of the Honorable Supreme Court.
Not required. We are accepting it.
But that is under, my lord, stay, my lord.
So it will be considered. We are not stopping you. We are not coming in the way of considering.
And the matter has been, my lord, decided by the single bench. And your lordship knows, my lord, whether the single bench can pass the order or not.
No, sir.
Your lordship knows.
Know
And
the provisions in the rules
yes,
also.
and now that is this
So you
this
have,
issue.
where is your objection before the tribunal to its jurisdiction?
But that matter is now pending before the special bench, my lord, for consideration.
What matter is pending?
Whether this special bench or division bench can be considered or not.
Sorry, sir, that is very much there in the act itself, act and rules.
No,
The power is there to frame the, to issue notification.
no, my lord.
Those matters in which no question of law is involved, like this case. It is a case of recovery. Both parties have agreed before the tribunal. What is this? Where is the question? There is no question of jurisdiction. No question of jurisdiction.
No, I think.
Show the provision. You are arguing without the book.
No, that provision, my lord.
Very nice. Very good assistance you are giving us.
No, I am told, my lord, my landed.
What told? You are here arguing.
No,
Don't
no.
shift the blame on your.
No. Another matter was, my lord, was being heard by my
You
lord.
have raised an objection that why single judge has heard the matter.
My lord.
Notification is to be issued under rule or section 5.
Section
Where
5.
is the book? Show us. This is the way you will raise an objection. Casually. And you are looking right and left. Very unique.
Oh, sorry.
Very unique way of assisting the court.
Sorry, my lord.
Very unfortunate also. We expect you to go through the provision and tell us also. You are not even seen the
No,
provision.
your lordship has passed one matter.
Not even seen the provision, sir.
No, your lordship is on
Which
past.
provision? Tell us.
Under section 5, your lordship is in.
Section 5, which subsection?
At subsection 4 possibly, and
What does it say? Tell us.
and your lordship has passed in my matter, my lord. Today, my lord, I
What
mistakenly
is the
forgotten.
provision? Tell us.
Wait,
This is not the way. It is not a forum where you come just for a casual conversation.
no, my lord. Your lordship.
Versus the court.
Your lordship is
So I
already.
should remember. Unique submissions you are making.
Your lordship is already passed order, my lord.
So there.
No, and another matter, my lord. And another matter, my lord. No. I am not on that, my lord. Judgment আনবে না, বই আনবে না, কিছু না, আমি কত তোমাদেরকে অ্যাসিস্ট করবো বলো তো? বলুন কাউকে।
Item number 5.
5, my lord, I am for the respondent.
5. Mr. Himanshu Ghosh is appearing for the petitioner. He suddenly left the court today due to sudden illness of his
Not
father.
today.
Kindly make it not today, man. Right.
You are for?
I am for the respondents.
It's a Union of India.
Union.
Union of India is the respondent.
Oh, in presence of learned counsel for the respondent, prayer is made for not today. Matter is adjourned for the day.
And I am grateful.
Item number 6.
At item number 6, I beg to appear on behalf of the petitioner.
I am for the state respondent.
My lord, two things I must point out before your lordship takes up the application. My lord, the exact date of advertisement is not specified in this writ application. And my lord, the date on which the renewal for OBC certificate was made is also not, my lord, specified. The OBC certificate renewal. Now, my lord, the issue is OBC certificate. Yes, it has to be, my lord, renewed in terms, my lord, of the OBC B certificate. That date is not there because it says, my lord, then lordship will kindly grant me some time because this initial advertisement is also not on record. My lord will kindly grant me a liberty to file a short supplementary affidavit.
That
know,
was
my lord,
not
it is
part
not
of the
proper.
record. That was not part of the record before the tribunal.
Not also before the tribunal. The original
Then
OBC
we will not look.
certificate.
Then we will not look into it.
Then, my lord, let me, my lord, make submissions with regard to, my lord, the provisions. May I come back, my lord?
Yes, we, at least speaking for myself, I would like to know what are the
Yes.
provisions for reservation in
My
the
lord.
state, because there may be some variance.
Yes,
So
my
I
lord,
would like to
absolutely.
And you are for?
I am appearing for the state respondent. He is my
both.
my senior.
So tomorrow, come with the provisions, we can
Yes,
proceed.
my lord.
Both of you, please, we
Yes,
would
yes,
like,
I shall produce.
this concept of OBCB,
Yes, because OBC one, my lord, maybe
Subject to your lordship's kind correction, my lord. That is not the issue in dispute. The dispute is, my lord, according to the, my lord, interview letter, she is required to produce a certificate, my lord, revalidated within a 1 year time. That she failed to produce on the date of interview. Therefore, she violated the terms and conditions of the interview. And I think this is an admitted
this is
position.
admitted
It is
position.
an admitted position.
Gijroya's case or something.
No, my lord.
Then-
What happens is, my lord, the OBC certificate was issued to me in 2019.
Yes.
Now, my lord, the
No, let us,
ad-
first thing first,
yes,
there is no dispute that there is a case under OBCB.
Yes.
it is
There is
OBC.
no dispute that OBCB requires renewal.
Yes.
So this much is not in
These are
dispute.
admitted.
These are
Alright,
admitted.
then
These are
yes,
admitted.
then
Now, my lord, I applied for the post under the OBCB category. The advertisement specified at a later date, the original certificate can be produced before the authorities. Now, my lord, the selection process continues. I take part. When the results were out, my lord, I was put under the unreserved category. Now, my lord, obviously the unreserved category's cutoff marks is not, which is, my lord, specified for the OBCB
so
category.
your consequential exclusion,
Yes,
that we have
exclusion.
understood, yes.
Now, my lord, what, my lord, we, my lord, beg before your lordships to consider is whether, my lord, 2019 certificate, the fact remains is that I am an OBCB candidate. This is undisputed.
No,
Now-
that's why we are saying there's
Yes,
no
that's why,
question
my
of
lord, let
not
us
being
come back.
disputed.
Yes.
Because your identity or your eligibility is hinges upon a certificate which admittedly requires renewal. So renewal was required in terms of the advertisement to be within a year preceding the advertisement.
Yes, my lord, the language, lordship, my lord, should I come back or, my lord, today, my lord, because I will be wasting your lordship's time, because, my lord, if I can come back tomorrow with the provisions, I will just only take some time of your lordship, my lord. The advertisement specified that I have to show the revalidated certificate at a later date. Now, my lord,
Correct.
yes,
Showing of the certificate is immaterial. They are
Immaterial.
saying you have to acquire it within a year prior to the advertisement.
yes,
So if you have it, you may show it at any date. If you don't have it, can you be permitted to show it
but
if it is not within the 1 year period?
absolutely, my lord. That is where I mentioned the date of application for renewal is not mentioned. If I can show before your lordship that the renewal was made and the authority kept it pending, probably I have a better case, my lord.
Oh,
That is why, my lord,
therefore he is relying.
because if I have made the renewal application and the renewal has not come in my favor within the specified time, then probably, my lord,
You made the application within a year.
yes, 2019 application renewal was made. That document is also there, my lord, by the state authority has stated that yes, the renewal is pending. Now, my lord,
Still pending.
no,
At
it
the
has
time
been,
of decision, it was still pending.
no, subsequently it was granted. It April 2024, subject to correction, my lord. The state authority has, my lord, given it to me. Now, my lord, this is why, my lord, I specify after going through the brief that the exact date is not recorded. This is our fault.
No, but if there is you are saying both things. One, you are saying date is not there. The other thing you are saying is that it is admitted that it was applied for renewal within a year.
It is
If
applied.
it is admitted, then where is the date is immaterial.
My lord, why I say it is admitted, because there was no scope for the state to deny it over there. My lord, it was only
That
on
does
the
not
basis of
make an
state.
admission.
Yes, that is why,
An
my lord,
admission has to be an admission.
admission. So there is, my lord, no
So,
specific
but then
admission.
don't say that there is an admission. You said for there is an admission.
No, my lord. So far as the renewal is considered, I never said there is an admission. I said that I belong to a OBC category candidate is admitted.
No, you assured another thing,
my lord.
that I applied within time is also admitted.
My lord, that is why, my lord, I very outset mentioned that date is not specified. I
But
cannot
then
make
how
a
do you
submission.
say that you applied
I
within
cannot,
time
I
is
cannot,
admitted?
I
You
cannot
don't
say that.
make such submission. That's why we are saying.
I'm absolutely sorry, my lord.
Yes.
That's why, my lord, at the outset I mentioned that the date is not specified.
So what is not before the tribunal, we are not going to consider. You have
Hello.
chosen to approach the tribunal with a particular set of facts and
Yes,
circumstances,
yes,
which they have replied, and the tribunal's order is to be judged on that basis.
yes. And it's given in a negative, stating, my lord, kindly takes up the
You have submitted a certificate of 2019.
Yes.
November 2019, where it was required to be after January 2020.
That probably is, my lord, probably, my lord, I must not say that, but the specified thing is that prior to the 1 year prior, that doesn't mean that it cannot go beyond that. It cannot come within 1 year. That was the, my lord, advertisement consideration.
It cannot be, it has to be the other way. Otherwise, a lapsed certificate can be relied upon. That cannot be, that's not a possible reading of the provision.
Exactly, my lord. That is why I say that the date of
Therefore,
renewal
if,
is very important.
huh?
When I have applied for
Not at all, sir. The date of certificate, when the certificate that you are relying upon
Yes.
is already there, where's the question of any other application? You have relied upon 14/11/2019 certificate.
2019 certificate.
So whether that will suffice or not, that is all that has to be seen.
Yes.
Let us see what is the requirement as per the instruction.
My lord, it comes in
Page
page 30. Page 30. Page 30, my lord. See. The first paragraph, my lord, two paragraph. A candidate belonging to OBC A or OBC category.
Then the instruction says certificate issued by the competent authority. This is the question. You see, it has to be between January 2020 to January. 1 year means 2020, January or 31st December 2025. I would know. Therefore, a certificate which is issued before this, it has to be within. Where is the instruction? Page 30.
Yes, page 30, my lord. It says, my lord, may I read it, my lord? A candidate belonging to OBC A or OBC B category shortlisted for interview has to produce revalidated, renewed, or fresh OBC A/B certificate issued from the competent authority within 1 year. Within 1 year.
So,
no, my lord, there is another part, my lord. May I read? Within 1 year preceding 1/1/2023 during verification of testimonials at the time of interview. Therefore, the certificate issued before 1/1/2022, which I am in, needs to be revalidated, renewed from the competent authority. This is where I am on. If I can show before your lordship that that renewal was made within a specific time, then probably, my lord, I will come under this clause.
you may not.
Only this part I will be. Then, my lord, I will not trouble your lordship with any further, because this is what, my lord, my lord, thought, my lord, will be proper to mention before your lordship.
Here proceeding 21/1/23, 1/1/23.
Yes.
Or 22.
23.
Therefore, any certificate, my
It is
lord.
1/1/23.
Yes.
So
But
the
1 year
tribunal
preceding 1/1/23.
The tribunal has taken a wrong date. It is 1/1/21.
Printing mistake.
1/1/21 is probably, my lord.
Yes, that is a my lord,
Typographical error appears.
mistake.
Typographical
But, my lord, this instruction is absolutely clear, my lord, that the cutoff date is, my lord, must be, it is between 1/1/22 and 1st of January 2023. Therefore, any certificate issued prior to 1/1/22, here it is 2019, it has to be, my lord, revalidated or renewed. And my lord, all candidates, my lord, got adequate time, my lord.
My lord, in page 80, absolutely. That date probably was not given for that reason only. Because 2022, 24. Status will be the same. Absolutely. my lord. Yes, and I have not made out a case also that these rules will not apply. I cannot better the position.
OBCB, yes, my lord, that I shall produce. Day after tomorrow. আরেকটা কপি তো কপি না না বুঝতে পেরেছি, ঠিক আছে, আমি জাস্ট দুটো ক্যাটাগরি আছে না, ওবিসির আন্ডারে ওবিসি এ, ওবিসি সেটা কোথায় পাবো? My lord, this is one of the provisions, my lord. This is dated 27th of July 2015. My lordship will find that this is updated guidelines for issuance of OBC certificate. Now, kindly, my lord, consider, there's no pagination, my lord, kindly consider,
Statutory provision, or it is
my lord, this original memo, this guideline, there is one guideline, my lord, framed under 309, But this one, my lord, I do not know. I have to take instruction. Paragraph 14, my lord, your lordship will find renewal of caste certificate of OBC. This has been quoted in the advertisement. This is, my lord, second last page. Since issuance of OBC.
Oh, okay. So this is depending on the creamy layer. Whether you continue to be a non-creamy layer or not, therefore it has.
That is the object. I am in a non-creamy layer. That is also my lord a position. It's really for the purpose to show that the reservation is no more required for that person.
Then this appears to be. You want to show us the application date?
Your lordship permits still, my lord. I know, my lord, what has fallen from your lordship. I also, my lord, feel that personally.
Most
it cannot-
probably, yes.
Cannot be beyond 2020. It will be a futile exercise.
But you do it if you want, we'll allow you. In the larger interest of justice, let him show what is the date of application.
Yes, my lord.
The
Grateful to you.
learned counsel for the petitioner submits that his application that he would be placed
Item number 7.
I'm for the petitioner. My lord, the respondent as applicant.
Mr. Mukherjee, can you what is OBC B?
OBC E is one of the weaker sections, and more weaker section is OBC A.
Oh.
And weaker sections, this then depends upon the income and
Poverty level.
poverty level.
OBC A and OBC.
Huh?
OBC A and OBC. OBC A is more poverty level, and OBC is general poverty.
Just like
Scheduled caste and scheduled tribes.
no,
Some-
scheduled caste, scheduled tribe is
specific
different.
case.
And, because of OBC has been because of Indira Shah's judgment. Following that, when state government classified as 2000 by the declared to be ultra vires by the Honorable Court, SLP is pending and waiting and all appointment up to 2010.
The SLP has been
Step-
decided. SLP has
Disposed
been
of
decided.
No,
That-
no, no.
in favor of
clarified by the
central.
West Bengal government,
The
OBC A,
SLP has been
that has been
disposed of, declaring that all categories which were declared as OBC
right.
by the state government, state of West Bengal, is not proper.
Supreme
Because
Court
they
has
did
been
not
heard.
consult. As per the act, it is a requirement that they have to consult in consultation with central government, that notification has to be brought in. There was no consultation. It has been upheld, Your Lordship.
They made the OBC A without taking into OBC commission.
And it was a specific
Apparently, they
notification
have
brought
included
for
some-
a particular caste of religious people, not to entire community. I will hand it over after the lunch. Your Lordship.
Yes.
Yes, I will give the SEC number.
Lordship. Item number 7, my lord. The respondents as claimant filed this application before the Central Tribunal, my lord, for challenging, my lord, the order of removal dated 30th July 2007, my lord.
You are for the railways.
I'm for the railway, India Railway, my lord. My lord, if your lordship kindly comes to the.
So he has Been dismissed on which date?
My lord, order of dated 30th July 2007.
30.
2007.
No, 30th July.
30th July. 307 2007.
2007.
Lordship.
And when did he pass away?
He passed away, my lord.
2014.
14.
2014.
Lordship.
Give the date, please.
17 June 2014.
Now, my lord, can you come to?
No, you have not given the date. You give us the date.
He died, my lord. And he expired at page, my lord, 48. My lord, he expired on 17/6/2014.
Yes. So the termination was set aside.
It was, my lord.
When?
It was by this order, my lord. This order is passed by, my lord, order dated.
Oh, so by the
This is the impugned order.
by the impugned order.
My lord, if your lordship kindly comes to the.
No, but prior to that, after termination, he had gone up to the appellate authority.
No, that is my point. This is my point.
So the tribunal interfered against the order passed by the disciplinary authority.
Yes, my lord, it's page 60, my lord.
Page
60.
6.
This is the order of termination, 60.
No, let us. Just show us the proof of service of charge.
My lord, that has been, my lord, service was not complete because, my lord, admittedly, he's.
Any paper publication?
Publication was made in the board of the office, my lord. And my lord, it was sent and it was returned, holding that
Undelivered.
not delivered.
Then what can be?
It was published in the notice board.
Notice board, now there are many judgments. What is the veracity of advertisement on notice board?
Page 62. 62 there. Page 62.
TCS mandates publishing notice on the notice board. Does the CCS provide that as a mode of service?
My lord, it was sent to his residence.
Don't say notice board again. You are saying. Therefore, we are asking you.
My lord, I say, my lord, 2 steps has taken. By two way service made, my lord, by sending to his home address and which has returned.
Undelivered.
As absent.
Undelivered.
Undelivered. And also attached in the office board, my lord. This is, my lord, admitted case.
Address to the office also.
Yes.
Okay, we'll see just after recess.
কি বলছিলাম তোমার আমি বার করে নিয়ে আসবো তাহলে এটা যশ actually.
Right.
फाइल में नहीं, फाइल में नहीं चाहिए।
Item number 17.
Lord, I appear for the petition. No, this is the affidavit of service, my lord. Pursuant to lordship leave, I have served the respondents. My lord, the government leader was served on 14th. Email was sent on 14th, and my lord, today itself the hard copy is also sent. By post also 14 sent to the my lord West Bengal Health Recruitment Board. Now, my lord, this is a case wherein petitioner before lordship approached the learned tribunal, my lord, on 6 May.
Who is appearing for the state?
My lord, I have served on 14th. Your lordship granted me leave. I served on 14th, my lord, to the government leader by hand, government leader, my lord, and I made an email and speed post to the HRB on 14th itself. And my lord, today itself by hand I have served the HRB as because 14th was a holiday.
So that means this has not been served on the respondents yet.
Well, I have served the government leader on 14th itself. The lordship will find the and today I have served the other respondent number 2 and 3 by hand today, and my lord, by email I have served on 14th.
2 and 3 you have served?
Yes, my lord, by hand today, and my lord, your lordship takes up page 6 by a mail, my lord. I served the my lord, the scanned copy of the petition before the respondents.
So what is the issue? Let us see.
The issue before lordship is this, my lord. The petitioner before lordship is a doctor and wants to participate in a selection process to be conducted by West Bengal Health Recruitment Board. Now, my lord, initially, my lord, an advertisement was floated. My lord, the advertisement said certain criteria. Along with that, one of the things that is to be uploaded along with the application is a chance certificate. Now, chance certificate is a certificate by which, my lord, in how many attempts I have cleared part 1, part 2, part 3, part 4. This is the chance certificate. My lord, initially
part 1, part 2 of MBBS.
Of my lord, this is a homeopathic doctor, my lord. It's BHMS.
BHMS.
So, my lord, this is the chance certificate was there. But initially, my lord, I must say, my lord, I must be candid. When the first application was filed, my lord, the chance certificate was not uploaded. Now, my lord, as the chance certificate
did not upload these certificates
at the first time. My lord, they given a window to all the candidates who have this discrepancy or certificates were not been uploaded. My lord, thereafter I upload the chance certificate.
Which certificate? Oh,
This
the chance
certificate. Mark sheets were there, my lord. Mark sheets and everything were there.
So there was a stipulation requiring the chance certificate also be to be uploaded.
Yes, my lord. Yes, my lord. So, my lord, first time
was that relaxable?
My lord, they have kept a window open later on, so that those who have not given the chance certificate or with the chance certificate, some discrepancies are there. A further time was given to upload the chance certificate after the final date of application, my lord. My lord, I uploaded the chance certificate on that day. My lord, they came with a rejection order, second rejection order, stating that your chance certificate which has been uploaded, it is after the date of the last date of filing the application. But again, one window was open in the month of December 2024 till, my lord, 2nd of January 2025. Now, my lord, I uploaded a chance certificate that gives the date that within the time and the chance certificate was uploaded. Now, my lord, they have come with a new plea that the certificate which was issued by the principal of the medical college, it doesn't bear a memo. On the same pretext, my lord, I can show, my lord, I have annexed the documents and I have also other documents are with me, my lord, where from that very certificate without memo are being allowed to participate on 18th. And in my case, my application was rejected on the pretext that the chance certificate which has been uploaded by me doesn't contain any memo. My lord,
Where is that order?
my lord, I'm just coming. The rejection order, my lord, the second rejection order, if lordship kindly takes up at page, last rejection order, page 59, your lordship take up 59 and 60.
No, this is pursuant to, where is the second window that you were?
Yes, my lord. That is, my lord, your lordship takes up, my lord, the second window at page 57. This is an order dated, my lord, a window dated 18th of December 2024.
Just give us a minute.
Mark kora ache, mark kora ache.
অর্ডারটা কোথায় আছে? ইমপিউন অর্ডারটা
ট্রাইব্যুনাল ডেট দিয়েছে, ডেট পরীক্ষার পরে।
Tribunal has not yet admitted the application.
But tribunal has on the contrary fixed a matter, my lord, after the due date is.
Just let us read.
Mention of date দিয়েছে পরীক্ষার পরে।
Where is this requirement in the original notification?
My lord, the original, but the advertisement is at page, my lord, 31. It starts from page 31, and the, my lord, the requirement is at page 34. Page 34, my lord, if your lordship takes up requisites qualification, my lord, is 1 and 2. 2, my lord, second dot, I mean, second bullet, I may say, attempt stroke chance certificate. There is no separate field to upload attempt chance certificate. Candidates need to upload it along with the mark sheet pass certificate of bachelor degree in homeopathy from a recognized university or institute as included in the second schedule of Homeopathy Central Council Act 1973. So, my lord, I been passing the homeopathy examination, that is not in dispute. Lordship নিজে লিখেছে।
সেটা তো আমাকে দিতে পারবে। কাল সকালে সেটা আমি ড্রাফট করা চলছে।
একই জিনিসে অন্য লোক অ্যালাউ করছে আমাকে বাদ দিচ্ছে, হ্যাঁ, একই সার্টিফিকেটের ওই দেখুন পল্লী স্কুল কোনো মেমো নাম্বার নেই।
Now, where is the rejection?
Rejection is at page 59 if your lordship takes up. Last rejection is page 59 and 60 is another. This is up to This is in the website, your lordship takes up. Application, your application is rejected. Well, detailed reasons, last line, my lord, if your lordship takes up. Page 59. Detailed reason. No memo number given in the chance certificate. Well, this is the ground. And my lord, I can show, my lord, the documents.
And what did you say at page 60?
60 is the same thing, my lord. This is a screenshot taken in the mobile phone, my lord. This is the.
And where is your chance certificate?
Well, my chance certificate or last chance certificate, which was uploaded, my lord, that is at page 58.
And you are saying others have been allowed.
Yes, my lord, your lordship will find I have documents. My lord, if your lordship takes up these two documents, my lord, your lordship will find these two chance certificates were issued by one candidate. His admit card is there, and she was allowed to appear on 18th.
No.
My lord, first two pages are the certificate issued by the authorities concerned, and my lord, the second two pages, my lord, are the admit cards of the same incumbent. My lord, Polomi Kishku, your lordship will find this. Puloma Kishku, your lordship will find the certificate without memo.
Sir, this is not after 1812.
No, this is not after 1812. Also, this is not after 1812.
So after 1812, who knows? She may have submitted a better one. Since an opportunity was granted.
My lord, this is a certificate I'm being told. Not only that, my lord, if your lordship will find.
We can't rely on it like that.
Well,
whether this is submitted pursuant to the second window or not, nobody knows.
My lord,
in fact, everybody knows it is not submitted after the second window. It is much prior there. At least 5 months prior there. So when maybe she would have submitted after 1812, she would have submitted with the memo number.
Well, subject lordship, kindly, my lord, this letter of chance certificate was issued on 12/7 after the first window was open.
How is that relevant to our query? Lord, we are asking you admittedly, it is at least 5 months prior to the second window. Admittedly, you cannot improve that fact.
That's true, my lord. Your lordship will find.
Therefore, that cannot be relied upon to claim any parity in any regard. Because after that, a window was opened on 1812 that you may submit. Who knows? They may have submitted with memo number. At that occasion, they may have been rejected with the same reason. We don't know.
Well, what I am beseeching at this stage, my lord, subject to kind consideration is this, my lord.
Basic qualification, if you are not able to comply with the
well, I have fulfilled the qualification with regard to certificates are concerned. Well, even my certificates, your lordship.
Sir, it is a very relevant factor which they are trying to ascertain, because for every chance you are deprived of 0.5 marks in your merit assessment, and that also a maximum of 10 times.
Yes,
so therefore, it is a very relevant requirement. It's not something technical that even if you have not done, why should you not be allowed to give it subsequently or anything like that? The law is very clear in this regard.
My lord, only thing subject to kind consideration, my lord. The chance certificate which I uploaded, my lord, it clearly says, my lord, with regard to the part 2, final part.
What is the authenticity? If somebody verifies it, what will they say? It is issued from the institute. What is the whole purpose of giving a memo number on any official document?
To give it official color, my lord. That's true, my lord. It's to give official.
What is the authenticity of such a certificate which you are relying upon? And for this, an interim order is to be passed. Prima facie case, at least you should be able to.
My lord, your lordship kindly takes up my results, my lord. Results will speak for myself, my lord.
No, sir, we will not. That hardly matters because your result will vary admittedly. It will diminish by at least 2.5 marks.
My lord, I am agreeable to that marks if chance certificate is there, my lord.
You may agree, but we don't know whether that is correct or not. It may be 3.5 marks.
Well, whatever,
maybe 4 marks.
Well, whatever the deductions is there, my lord, is in terms of rules, my lord, I
is your self-serving statement. We have to look at it dispassionately. We have to look at the documents dispassionately. An application was to be filed accompanying the chance certificate.
Yes,
you did not file. Window was open for uploading any documents which you may have missed. Then also you did not. Second window was open, then you have submitted. You have submitted something which on the face of it, prima facie,
my lord, when the
does
first
not make out any case, let alone a prima facie case.
My lord, subject lordship, when the first window was open, my lord, I
that
uploaded
is
the chance.
immaterial. You have not
given a
come at
chance.
that stage.
But
You
then
have
they
not
said,
come at that stage.
my lord, when the first window was open, my lord,
You have complied with the second. Why are you repeating? We have said that now they have given a new ground and all that. How is that relevant?
well, the
You
first
have
rejection,
accepted that rejection. You have complied with the second window.
yes,
You
my lord.
don't want to decide the issue, right?
Well, the first window, the rejection was there, my lord, on the ground that it was not within the time
Or
frame.
how many times
I
you will
understand,
say
but I
that?
understand, my lord.
How many times you will say?
My lord,
Not within time, then you say now a new ground. All that we have heard. You have accepted it by your conduct. You have complied with the second requirement. The second requirement you say is complied. They say we cannot find out. It's not verifiable. It cannot be. When the institute which has issued it does not even give a memo number, how it can be verified that it has been issued by that institute or not?
my lord, subject lordship, kindly, my lord, the my lord, the memo, the chance certificate issued by the institute itself, government institution, my lord, it can be verified at any point of time. But what I am beseeching is mere chance to sit for the examination. Let my results be withheld, my lord. Pursuant to the leave, it cannot be published.
No official communication.
কে পাঠিয়েছে? কোথায় পাঠিয়েছে? নেই। কোথায় পাঠিয়ে নেই? হ্যাঁ, বলুন। But only thing your lordship will take note. My lord, tomorrow is the examination, my lord. The problem is this, my lord. This is going to be the last chance of the petitioner. And my lord, your lordship will also find the principal and administrator is a party in this original petition as well as in the original application. Mr. Mukherjee is representing him. My lord, with regard to this veracity or authenticity of the document, my lord, Mr. Mukherjee can very well applies the court. What I'm beseeching is this, my lord, let me be allowed to participate, my lord. Whatever is there, let the matter be fixed on a day. Let Mr. Mukherjee come with an instruction that this certificate has not been issued by the competent authority. Your lordship may dismiss my application with cost. But this is my categorical submission. What I've got from my client is this, my lord. This is the certificate issued by the same officer, the principal and the administrator, my lord. My lord, and my lord, this cannot be a ground, my lord. The mark sheet will say, my lord, how many chances I took. So, my lord, whatever is there, subject to result of the petition over here or before the tribunal, if the authorities say this certificate is not genuine, my lord, my candidature will be cancelled. I may be imposed cost, my lord. I don't mind, but I will be out of the court.
Can you see prayer in the original application at page 29?
28.
Pray for a consideration of the representation.
What an interim prayer. What is an interim prayer? What an interim prayer, sir.
No, interim prayer.
Main prayer,
page 28.
Main prayer 28, sir. So page 28 is the prayer. Page 28. Sorry,
Please allow him to.
Extremism.
We heard you. We have made all the submissions. We'll again come back to you. Don't worry. We only express because we want you to clarify. Therefore, we express it. We have not arrived at any conclusion. You please sit down. Sit down. Just give us a minute, Mr. Mukherjee. Yes.
Page 29, paragraph 10, II. Pending disposal of the application instead original application, the respondent authority directed dated 25 made from the classification order, splitting order. But only this order could be passed. Consider he is represented.
That can be considered by the tribunal.
But that is the interim prayer. My learned friend is not reading the original prayer. Page 28 is the original prayer. He is reading the interim prayer.
Page
28 of the original application is the main prayer, my lord.
The inter-selection process.
Yes, but this is all the interim relief you have sought for.
My lord, your lordship will find a sought for of the interim prayer, my lord, to keep one post
Cannot
vacant.
get the final relief by way of interim relief. You can only get interim relief by way of interim relief.
My lord, interim relief, one my lord said one post be kept vacant. Let that be there.
That can be done by the tribunal. It need not be done today. Tomorrow is only the exam. It's not that the post will be filled up in one day. After the exam result has to be declared and then joining. So what is this?
No,
There is
no,
no
so
urgency.
so far OBC is concerned, that's why for a selection process going on, but no final selection would be made until the matter is decided by the Supreme Court.
We don't know. Even if they proceed with a lot of expeditiously, it is not to be done in a day or two or in a week or 2 weeks. It will take time. By now, we have sufficient idea that these things don't conclude in 15, 20 days or in a month. It takes time. And what is it? 1-tier examination or 2-tier exam?
Well, so only interview, my lord. The day, my lord, I will be there, my lord. My documents will be verified.
There is no exam.
No, my lord. Then, my lord, practically one day everything would be over.
There is no written exam.
No. No, my lord, no written exam. It's a walk-in interview, I may say. My lord, only the mark sheets are to be taken into consideration. My marks will be, my lord, the main 15-number marks for interview. And it can be done, my lord, within a span of a couple of hours.
You are not able to make out a strong case.
Sir, what I'm beseeching is only participation in the selection process, but nothing more. But I know my fate may be sealed even there. I may not be getting chances, my lord. What I'm beseeching, only humble request, my lord, before lordship, my lord, let me participate, my lord, let me take my chance. This is last opportunity I'm having. My lord, subject lordship kindly, my lord, if I'm being allowed, my lord, I don't think that heaven will fall on the state. But if they am not allowed, my lord, the heaven will fall on me.
This is a public employment. This is a public employment.
First, let the petition be kept pending, my lord. If your lordship ultimately finds that this certificate is said to be not genuine one, your lordship may.
We are not going to embark on that inquiry at all. That's not our domain. To look into the correctness of the certificate, we will not go into that.
Well, let them,
that will be decided by them.
Let them be decided by them.
That we will not go into whether your certificate is correct or not. That will not. It's not our jurisdiction.
My lord, let me then participate in the selection. This cannot be ground of rejection. Should be taken away.
What do you mean this cannot be a ground for rejection?
No, my lord,
a certificate not bearing a issuance detail, and that should be accepted.
Let that be, my lord. Let me
How
participate.
can you say that should not? That cannot constitute. That is a very valid ground for rejection.
My lord, let me participate. This is my only prayer, my lord. Lordship kindly considers, my lord.
You have not been able to make.
My lord, I may say, my lord, the balance of convenience is in my favor. Subject lordship kindly.
How is it? Balance of convenience will come after you make out a case. And what is the date on which this certificate was issued?
My lord, this certificate was issued on 16th of March 2024.
16th March 2024.
My lord, page 58, your lordship will find.
And where is the first rejection?
First rejection is, my lord,
page 52.
52.
52.
My lord, detailed reasons, my lord. Attempt chance certificate is not uploaded. Please upload the document as per advertisement.
You said they have rejected by saying it is by belated.
My lord, this is the second rejection is there, my lord. This is the first rejection. Second rejection, my lord, although it's not that very clear, but I'm reading it out. Page 55. Issuing date, attempt chance certificate is after the stipulated date. 21, this certificate is not in this one. 21/3/2024 of final submission as per advertisement. My lord, this certificate which I've shown in page 58, my lord, is not that very certificate. That very certificate is very different.
Where is that?
My lord, after the window was open, my lord, I again approached.
Oh, where is your 21/3/24 certificate?
My lord, that certificate, my lord, your lordship takes up, my lord, that is page 54. My lord, this is the chance certificate issued by the competent authority on, my lord, 6th of July 2024. That also doesn't bear any memo. They have not rejected on that ground. Page,
What is the date of this second rejection?
date of the second rejection. My lord, the chance, your lordship takes up page 53. It must be in and between 5/7/2024 and 15/7/2024. Page 55, the first time, my lord, the window was open. The 21st March night, it's a DSA, কি করে হয়?
21st March.
It is, they are saying date, last date of interview was this. Application form Jama. Well, your lordship will find page 53 is the first window was open. It says, my lord, from 5/7/2024 to 15/7/2024. Page 53. 53. Page 52 is the first.
5/7 to 15/7.
Yes, my lord.
This was the first one.
This was the, my lord, the first chance certificate which was rejected on the ground that the certificate which was issued by the competent authority, the date was, my lord, after the date by which the original, my lord, the application is to be submitted. That is 21/3/2024.
We are unable to connect the events. 29 to 24 required you to submit it by 21/3.
21/3, my lord.
Which you say you did not submit.
I did not submit the chance certificate for the first reason. That is the first rejection at page 52. It says
page 52.
52 is the first rejection that says I have not, my lord, uploaded the chance certificate.
Yes.
My lord, thereafter first
So
window
that
opens.
means this is before 21/3.
Before 20, after 21/3, before 5/7, in between that period, my lord.
Yes.
My lord, thereafter, 5/7/2024, the first window opens for all, including myself, wherein it says the chance, all and whose applicants have prima facie rejected are allowed to resubmit the information documents within the limited stipulated period with reopening of the requisite link, and for such candidate, upload the relevant legible documents in between 5/7/2024 2 p.m. to 15/7/2024 2 p.m. So this was the window given.
Submitted. It did not submit, then between 21st March to 5th July. He gave him an opportunity. Then says he submitted this. Page 50. It says the third opportunity was given on 18/12. No, on 18/12 when third opportunity was given, he has submitted this. This third opportunity bears a date prior to the second. Or 60. What is the date on the certificate, chance certificate that you have submitted on the last occasion?
Last occasion, my lord, that is, my lord, a certificate was issued, dated, my lord, 16th of March 2024.
Prior to the last date.
Prior to the last date. Reasons being, my lord, your lordship takes up the first why I did not upload the chance certificate the very first attempt. But if your lordship takes up page 51, this was a certificate issued by that very authority. It is not in proper format. After going to this, my lord, they have issued the certificate. Or if your lordship takes up, two certificates were there on that very day. Or if your lordship takes up, my lord, page 51, it says, this is to certify such and such ex-student of Midnapur Homeopathic Medical College and Hospital passed first BMS examination by one attempt, and BMS examination, second examination by one attempt, third examination by two attempts, and fourth BMS examination by one attempt. My lord, it was not in proper format, I may say, my lord, subject lordship kindly.
But this one is of the same date, sir. The
16th
last certificate is of the same date.
16th, my lord.
So both was there before you.
Yes, my lord. I could have done it, my lord. Had that been the situation, would not have had. That's true. It's fault on my part. That is the reason I'm saying I have not concealed anything, my lord. It's all on record.
No, it's not a question of concealing. It is whether you are able to make out a prima facie case. That is what we are trying to determine. You have a certificate which is on the format, which is of 16/3/24. You don't submit it by 21/3/24. In the second opportunity, you submit a certificate of July. And then in the third opportunity, again, you submit a certificate of March.
No, the second was rejected on the pretext that it was not within that
How
time.
many times you will say that?
That's true.
You have said that sufficient number of times. We are asking you, you have to come back with an answer on that. Either you dispel what we are trying to get over, or you
I may say, my lord, subject to kindly, my lord, when the first attempt was, first window was opened, my lord, I went to the office of the principal and administrator, my lord. He issued the certificate on that very date. The day I went to the office for the second time. My lord, I thought as because that was rejected, as because I have not, my lord, uploaded the churn certificate, I uploaded the certificate which was, my lord, procured, I may say, my lord, readily from the authorities office on 6th of July 2024, and I uploaded that. My lord, I was not of the impression to, my lord, say anything or, my lord, conceal anything from the authorities, my lord. I got the certificate, I uploaded it. First time, had that been in the first occasion, I would have done it, my lord, things would have been different. That was not done. It's my fault on my part. My lord, 18th, one date, my lord, the interview would. My lord, it's one day, my lord, it's walking interview, it will be over by a few hours. Well, one phase, I'm being told, one phase has already been complete. And this been the second phase. My lord, the window was opened, my lord, 18th of December to 2nd of January. My lord, my certificate was rejected only in the month of February, my lord. I made a representation straight away and moved the tribunal. I understand what is coming from your lordship, my lord, but the thing is, my lord, yes, my lord.
When the tribunal has fixed the matter to be heard.
My lord.
When the tribunal has fixed the matter to be heard.
My lord, it's on 27th of February. Well, I mentioned the matter on 12th. I filed in on 12th. I mentioned it on 12th. But had the tribunal would have taken up the matter today itself or my lord, on 14th, I do not know, my lord, things I would have not approached your lordship, my lord, in this situation. Well, I will be remedialist, my lord, if nothing happens to me.
The interview is only on what date?
Yes, my lord, it's a walk-in interview, only the mark sheets will be verified. My lord, 50-number interview is there, my lord.
No, no. For verification.
My lord,
That is 1 day be over. In 1 day, the assessment of the interview may be over. But all the credentials then have to
no, before them, and thereafter,
time.
It will take some time.
Yeah, here.
but
What do you think? How long?
My lord, normally verification of the documents is the first day, then my lord, my lord, physical appearance, whether he's then my lord, it will go to the committee, selection committee. They will verify everything from the original authority. So it will take some time. Minimum.
If they find anything, they will arrange.
my lord, then my lord,
Yeah. Or does not make out those strong things. One will have a certificate on the proper performance of marks.
my lord.
Certificate issued of
My lord. So this is what I'm being told, my lord, from my client, my lord. He's here. That's
at this point, we are saying that MFSC for us it is difficult. Still,
my lord, only thing is this, my lord, subject lordship kind consideration is this, my lord. If I miss the bus, my lord, if I miss the interview, my lord, I may not be there in the entire, my lord, this scheme of things. My lord, let my interview be subject to whatever there before the tribunal. Let results be kept in seal cover, my lord. Unless the tribunal decides, my lord, nothing will be out. No, my lord, in the original application I paid for the interim order, my lord. I filed it on 12th. 13th, 14th is a holiday declared by the state government. The tribunal remained closed. 15th, 16th was holiday, my lord, Saturday and Sunday. But today the tribunal is opening, my lord. My lord, MA, my lord, if I file today, my lord, as per the tribunal, what I practice there normally, my lord, I know that, my lord, what the tribunal normally does, my lord, it will be fixed, my lord. A notification was also issued by the tribunal. Normally, dates have been fixed after 21 days. Well, it cannot be taken up prior to 21 days, my lord. This is a notification issued by the tribunal and followed by the office of the tribunal. Today, I file a case, my lord. A date will first date that will come before the tribunal is, my lord, 21 days later. No, my lord, I had to mention this matter, my lord, before the tribunal, and then, my lord, I get a date. Yes, my lord. Your lordship will find the initial tribunal application which was filed and the date given by the registry is on 6th of March. Page 68. Your lordship, I filed on 12th. Date was given on 6th of March after 21 days. Now, my lord, I mentioned this matter, my lord. I know, my lord, tribunal is, my lord, there's only one member, my lord. He has got certain, my lord, the case loads are there, my lord. He fixed the matter at 27. This is the problem I approach the tribunal, your lordship, my lord. হ্যাঁ 12 তারিখে মেনশন করেছে পরে পাতা দেখুন সেটা মেনশনিং স্লিপ ট্রাইব্যুনাল ট্রাইব্যুনাল থেকে ডেট দিয়েছে এটা আমার তো মামলা ভুলে পাঠিয়ে দিয়েছে ট্রাইব্যুনাল ভুলে ভেটি করে ভুল করে এটা পরে দোষ 12 তারিখে তো মেনশন করেছে কতগুলো ক্যান্ডিডেট তাকে বিরোধ করেছে কতগুলো ক্যান্ডিডেট দাঁড়িয়ে লবচার Page 68 is the date given by the registry, and 69 is the, what I mentioned the matter before the learned tribunal. Yes, date of interview is at page 66. 66, my lord. 66, my lord, point 1. It is hereby. This is a notification issued, my lord, for all. Right? It is hereby notified that the second phase of interview of eligible candidates for the post of homeopathic medical college under WBHS will be held on such and such.
পোস্ট কটা
অনেকগুলো আছে পোস্ট
আরে পোস্টটা কটা বলো
এই ব্যাপারে মিটিং আছে 19
পোস্ট কটা Okay, just I've taken instructions. Similar to this, about 16 candidates are there.
all in the
All in the same condition, they have not submitted the documents, and that's why it in
19th meeting
19th board meeting is there.
board meeting
19th board meeting.
Board meeting.
For what? For what purpose?
For this type of cases, who has not uploaded the applications, about 16 candidates without memo, 16 candidates have been application has been rejected by them.
So if the meeting is there on 19th, if you have instruction, then we can record it that the issue is being considered, it is to be taken up on 19th. And the tribunal can take up his matter on 20th.
Yes.
Yes.
Make a humble submission, my lord. As
We
because
don't want to say anything.
well, I'm not saying any other
To
thing.
leave everything open
Have
for
tried
you.
my level best to help my.
No, we are also thinking so much because we think that whatever can be done, but for passing an order in this circumstance,
yes,
there is.
My lord, only thing, my lord, BCC, my lord, is tribunals fix the matter on 27th. But if 19th the board take
We have said we will direct the tribunal to take it up on 20th. They will. We will say that the state should also appear on 20th, and the tribunal may take it up on 20th is Thursday. 21st Friday they will take it up.
The Friday tribunal is not sitting, my lord.
Oh.
Friday tribunal is not sitting, my lord. Dates have
Leave it open to you that subject to what happens on 19th, you may move the tribunal for expedition.
as well.
Yes. Third learned counsel for the petitioner and the
so that I can place it before the viewer. Get.
Deeply. Deeply.
Item number 146.
My lord, may I hand over the affidavit of service, my lord?
Lord, I am appearing on behalf of the respondent being led by Mr. Ujjwal Rai, my lord.
My lord, the fact of the case is, my lord, I am before your lordship, my lord, to adjudicate one point, my lord. Here the case is, my lord, the respondent, my lord, is the daughter of an employee of a railway, my lord. And
For the respondent original application.
my lord, she had sought for family pension. She was divorced after the death of her mother, my lord. In 87, her father superannuated, and the father died in 1992. Thereafter, the mother died in 2008. My lord, then the respondent approached the tribunal, my lord, and the tribunal gave order in favor of the railway, my lord. Then that order was challenged, and the respondent came before the High Court, my lord. High Court, in its order, said, my lord, at the time of the death of the case of the respondent, my lord, there was a notification of railway which gave a blanket permission, my lord, to give family pension without considering this point that whether the death of the pensioners were after, before the divorce or after the divorce, my lord. Now, may I draw your lordship's attention first to, my lord, the order of the High Court, my lord, which is at page 57, my lord. May I place this order, my lord? My lord, I would draw your lordships to the ordering, draw your lordship's attention to the ordering part, my lord, because it is very important, my lord. till third last paragraph, my lord. No, my lord, it is my feeling, my lord, just for my satisfaction, my lord. For the aforementioned reason, we direct the respondent authorities to take appropriate decisions for grant of family pension to the petitioner herein as divorced daughter of the deceased employee in the terms of RB 98 of 2008, who was also admittedly staying with her mother till death without any further delay, but positively within 4 weeks from the date of communication. This was not a mandatory order, my lord. So I was directed to take decision, my lord, and accordingly I took a decision, my lord, and I communicated to the respondent, my lord. Now your lordship will come to the communication, my speaking order, my lord, which is just next page, my lord, page 60. I will not trouble your lordship much with that, my lord, but I will draw your lordship's attention that why I rejected this, my lord. It is at page 61, my lord. No, my lord, kindly bear with me for 5 minutes, my lord. I will clear all your doubts, lordship's doubts, my lord. My lord, I am not with the clarification here, my lord. What has happened in 2014, my lord, there was a notification. After 2008, there are notification, my lord, which clarifies that before the death, at least you have to file the suit, my lord. Old position, my lord. Now here in 2014, since the order of the High Court was that I am to consider the pension in accordance with 2008, my lord, notification of 2008, that went on, my lord. But in 2014, there is a notification, my lord, which says that whatever pension has been granted in terms of 2008, my lord, that has to be stopped for everybody. But it will not be taken aback, my lord, because it will be harsh here. But in case of the respondent here, my lord, we had not given her pension. So we are being restricted by that 2014's notification, my lord. There is a subsequent notification, my lord. My lord, that makes clear, my lord, it is at page. It is at page 91, my lord, 2017 notification. And my lord, all these notifications are. My lord, last rejection is, my lord. Last rejection. My lord, first rejection or last rejection?
16.
My lord, the tribunal is not considering this RBI 109 of 2014. Tribunal is at each instance, my lord, tribunal is straightway passing the order. There has been two directive order, my lord, one from High Court and one from tribunal. There was no mandatory order, my lord. In the second round, my lord, tribunal has passed a mandatory order. My lord, it is at page. My lord, I'm extremely sorry, my lord. That last sheet was left on, my lord. I'll hand it here, my lord. I'm extremely sorry for it, my lord. My lord, may I place the ordering part, my lord? My lord. Page 53, my lord. My lord. My lord, 14, if your lordship comes to page 88, my lord. My lord. The operative part is in page 89, my lord. Point number 3, my lord. Page 89, my lord. Last pensioner, my lord. 2008, my lord. My lord, the father expired, then my lord, father expired in the year 1992, my lord. Then mother expired in 2008, my lord. Matrimonial suit was filed in 2009, my lord. Ex parte order was obtained in 2010, my lord. And 2011,
order was passed is not relevant.
my lord.
Yes.
My lord has already seen, my lord, this honorable court's earlier direction. So, my lord, as has been placed before your lordship, that direction was, my lord, for consideration. My lord, subject to, my lord, correction from my lords, my lord, the entire orders, my lord, we always, my lord, see the honorable court's order in its entirety, not only the operative part. If I can once again take your lordship back to that particular order. If I request my lord, to come to page number 57, running page 57.
Yes.
My lord, it quotes the RBE 98 of 2008. Then, my lord, the next page, the page number 58. My lord, the submission of the learned advocates are also recorded. This honorable court's observation, my lord, starts at the bottom, the last paragraph of page number 58.
Yes.
May I, my lord, place that particular part?
Yes.
Be that as it may, the petitioner herein, being the divorced daughter of the deceased employee, shall be eligible for family pension in terms of the Railway Board's order being RBE 98 of 2008, wherein it has been specifically mentioned that a divorced daughter is eligible for family pension at any age, and no other condition has been mentioned by the Railway Board in the aforesaid order, although it is not in dispute that the petitioner was staying with her mother as dependent till her death. So, my lord, this is the observation of this honorable court, which led in passing the subsequent paragraph, which runs as, for the aforementioned reasons.
The date of this order is not legible. It is
The
13.
date of this order,
My lord, it is 13/6/2015, my lord.
May, it would be, my lord, May 13, 2015.
May or June?
I believe, my lord, May.
May. It is not.
It is May.
Yes.
13th May 2015, my lord.
So 13 May 2015, when all these, my lord, events which have been, my lord, depicted today by my learned friend, my lord, has been placed before this honorable division bench. And after consciously, my lord, dealing with everything, the subsequent Railway Board's order, my lord, this order has been passed. Even, my lord, this RBE of 2014 was also placed before the honorable
When they
division.
passed the order
Yes.
of 3/7/15,
My lord,
in purported compliance of this High Court's direction, did you invoke the contempt jurisdiction?
I did not. My lord, because subject to correction, my lord, J.S. Parihar was, my lord, standing in the way, because that was, my lord, my lord, a reasoned order, for which, my lord, I had to go, my lord, challenge before the appropriate forum. So,
Anyway, if
yes,
you submit that there was a specific mandatory direction,
so
then
the issue is decided. The issue about whether my eligibility to the family pension is right or wrong, whether am I eligible or not, that has been decided. The specific direction of the honorable court, that the petitioner herein being the divorced daughter shall be eligible for family pension in terms of the Railway Board number such and such, wherein it has been such and such. So, my lord, my eligibility is already decided by this honorable court. And after that, what, my lord, the honorable single bench, my lord, sorry, I'm so sorry, my lord, the honorable division bench, my lord, went on saying, for the aforementioned reason, we directly
shall be eligible means in terms of 2008.
Yes, in terms of 2008. My lord, this order was passed in 2015. My lord, they have referred the RBE of 2014.
My lord, subject to correction, that is not the correct notification which my learned friend is referring. If your lordship kindly sees the date of 2014, that is some other notification, 8 January 2014, but the notification I'm referring, my lord, is of date 18/9/2014, my lord. And this,
Where?
my lord, if your lordship sees at page,
No, no, where he is making a wrong reference according to
my
you.
lord, page 58.
Yes.
The learned advocate of the railway authorities, however, relies on an office memorandum mentioned in EST number 2/2014, dated 8 January 2014. This is not the notification of Ministry of Government, my lord. This is the office notification which refers to 2013's notification, my lord, issued by the office, my lord.
This is the 14 one. This is
The actual 14 one is, my lord, is at page 88, my lord.
Yes, so they're referring to
That
this.
was not referred before to the writ court, my lord. And the second point is this writ court passed this order, my lord, without an affidavit in opposition, my lord, without giving a chance, my lord, to refer all these notifications.
I believe, my lord, the special leave is allowed in that event. They did not even, my lord, prefer the appeal against that particular honorable.
My lord, I would answer to that also, my lord, because it was not a mandatory order, my lord. It was just a direction to take decision, my lord. So we took a decision.
Very nice way of conducting the court.
I'm sorry, my
proceedings.
lord.
Please argue against each other.
I'm extremely sorry, my lord.
And we will be left just gazing at you.
I tender my apology, my lord.
Yes.
Sorry.
Yes.
My lord,
So you say as per 2008, that we have understood.
so after that, my lord.
But even no, before
sorry.
you proceed further, even if we take it that it is a mandatory direction, then only as per 2008, not any in addition there. And what has been the fate of those who have received in terms of 2008 is obvious from the 2014 notification.
My lord, lordship has seen 2014 notification.
Correct. So even if it was to be given to you as per 2008, when the notification of 2014 would come into operation,
My respectful submission, no, subject to correction of my learned friend. I just tell your lordship, lordship has seen 2014.
Yes.
What does it refer to? My lord, let us once again, for the sake of reputation.
Yes, yes, yes.
My lord, 2014, my lord, is at page 88.
Yes.
So, my lord, it talks about page 88 at the bottom, my lord, the DOPT's instruction corresponding to the Railways Board's RBEs, my lord, mentioned. I do not find, my lord, the RBE 2008 is mentioned here. Now, my lord, I just request your lordship.
2008 may not be mentioned here, but substantially it is looking at the same situation.
My lord,
Whether it is to be given to all, irrespective of the date on which they have become a widow, and irrespective of the death of the pensioner or his spouse, his or her spouse.
I tell
That
you,
is the issue which was being considered in 2014.
Very well, my lord.
And they said, no, this we cannot permit, it has to be discontinued. It was a harsh or extreme step, but they said it has to be discontinued. We will not recover, but we will stop.
Yes.
Then they say in 2017, they realize that this is too harsh a step. So they make certain amends that, okay, such a person may not be at fault if she or he has filed a divorce.
Yes, ma'am.
While the pensioner or his or her spouse was still alive. So even if you take it as 2008 being a mandatory direction, it being a mandatory direction in terms of 2008 only.
All right, I just beseech your lordship. When this matter was taken up by the honorable division bench, my lord, the 2014 notification, which my learned friend is right now referring, is very well there. And lordship will also appreciate that while passing the order, what my lord, the premise on which this honorable court, my lord, has passed the order once again. It says, my lord, that paragraph running page 58 bottom, page number 59. It my lord goes as RB 98/2008, wherein it has been specifically mentioned that such and such is eligible for final evaluation has been mentioned by the Railway Board in the aforesaid order, although it is not in dispute that the said petitioner was staying with her mother as dependent till her death. So that is the further observation of this honorable court while passing this order. So, my lord, my respectful submission before your lordship that in this particular matter, this has been a unique situation which my lord led this honorable court to pass this order.
You say it is a mandatory order,
yes,
but you don't go for its implementation.
My lord, I just beseech your lordship, my lord, this has been, my lord, specified by the honorable Supreme Court, but in J.S. Parihars, that once a particular order direction is passed for the purpose of consideration, whatever be the observation, whatever is the order that has to be challenged before the honorable, before the appropriate forum, not in a contempt jurisdiction. My lord, that for that particular reason, my lord, I could not, my lord, go against that particular contempt proceeding, my lord, in that matter. So, my lord, that order, my lord, remains. And they did not even prefer any appeal against that order. So if this observation, my lord, they are aggrieved. They say that this observation is devoid of this 2014 because this honorable court did not take into consideration 2014.
No,
They could have,
we are going one step ahead. We are saying even if we take it that it is a mandate to give the benefits in terms of the 2008 notification. Will that close the issue once and for all, or any effect or change on 2008 notification will affect you?
my lord, that also, my lord, is answered by the honorable division benches. Because here the honorable division bench specifies that this incumbent is basically dependent on the father, on the family. My lord, I'm just relying upon.
Dependent married daughter is entitled.
Yes. My
Under
lord,
which
this,
provision? Let us see.
there is no provision. My lord, this is the interpretation of this honorable court. I ask beseech your lordship, may I hand up your lordship one judgment of the division bench of this honorable court where
This court in this order is taking notice of this fact because the widow, she was claiming to be a widow.
yes,
Have to have been considered together.
my lord.
It is considered that she is a widow and that she has been dependent on the parents while she was
My lord,
parents were still alive.
my lord, lordship will kindly appreciate here, my lord, in the judgment the dates are mentioned also. And also lordship will kindly see.
Dates are not in dispute.
My lord,
The dates are not in dispute.
yes. So, my lord, this
He is saying
all of them, my lord, have been taken care of by the honorable division. They cannot just re-agitate this issue now without preferring an appeal. What, my lord, is right now
There
being
is
done
a
here.
question of re-agitating. They have passed an order, you have challenged it. Why they are not re-agitated?
My lord, because there has been, my lord, I tell you, lordship. My lord, there was initially, my lord, the issue whether I was eligible or not.
Come with the, so that is your sheet anchor, come with Parihar judgment. So you say this is final and binding inter parties.
My
This
lord,
is
yes.
your case.
My lord, yes. Because there are, my lord,
But even if I don't, even if I don't go for its implementation, it is final and binding inter parties.
Yes, my lord, unless it is challenged before the honorable, the upper forum.
There is a question. The court has asked him to pass an order. They have passed an order.
My lord, I just beseech your lordship, my lord, there are few steps.
An order in contumacious disregard to the direction of the court will not constitute contempt.
My lord, this is what, my lord, I just tell you, if I just
therefore we are saying come with that judgment. We'll
very well, I can do that, my lord. I can do that. Or, my lord, one
and
point.
come with those judgments also that where the direction is implicit in the court's direction, even if it is giving an opportunity to the authority to pass an order.
I was trying very hard, my lord, to tide over J.S. Parihar in the honorable division benches. I could not find.
Oh,
it's my inability, my lord.
Anyway,
because I tried a lot.
All of us cannot.
But while I was moving a matter, my lord, before my lord Justice Datta was sitting with my lord Justice Bhattacharya. My lord, in the matter, my lord, I tried a lot. I could not. I lost the matter because of J.S. Parihar. Very well, my lord. My lord, yes, apart from that, my lord, I'll just come back. But one thing, my lord, may I just point out, my lord, there are stages of this grant of pension matters or grant of any benefit by the department. One, whether I'm eligible. In a particular score, whether the issue, whether at that particular juncture I was eligible. Then, my lord, comes whether I was having appropriate, my lord, monthly income, which would, my lord, make me ineligible further. So these are the situations for which this honorable court, after holding me eligible in one prospect, led the government take a decision on the further prospects. Very well, my lord. I just can come back to your lordship with JS Padi. I can just, my lord, if your lordship, my lord, puts it even tomorrow, I'm fine with that. I can do it. My lord, this is, that would be 1996 6 SCC 291. Yes, I'll just. Yes, ma'am.
So what is that? My lord, the tribunal has fixed this matter again on after 4 days, my lord, for attaching my salary. My lord,
Monday দেওয়া হবে, don't worry about that.
my lord, one line may be
No, no, no,
mentioned, my lord.
there may not be any line, man. Kindly, my lord.
My
do
lord,
not-
because my lord,
Because-
today it was fixed, my lord, and
But I just request, my lord, because I would have, my lord, come up with the judgment today. I am sorry, my lord, I did not.
Item number 7.
I'm for the petition, my lord. My lord, as it appears, my lord, challenging the, my lord, order dated 30th July 2007 in the earlier application. Lordship. No, my lord, as it appears, my lord, in the earlier application, original application, they have filed an order dated, my lord, 16th in 2015. The order is passed, my lord. At page, my lord, 124. 125 is the main portion. 6, in this actual matrix and in view of the submissions made above, we would like to issue the following directions. The applicant is given liberty to make a detailed representation to the respondent authorities concerned within a period of 1 month from the date of receipt of the copy of this order, etc. My lord. My lord, on that, my lord, detailed representation is made. Next page onwards. And my lord, the speaking order is passed at page 130. At 131, my lord, lordship, I can find it page 131, that it was treated as an appeal, my lord. Then it was rejected only, my lord. 2/3 of the pension was allowed in her favor, depending on a different, my lord, order, my lord. It is, my lord, compassionate allowance. Compassionate allowance, 2/3 of the pension is given. My lord, challenging that, (124), my lord, in earlier proceeding. Earlier proceeding, my lord. This is the third time I have find, my lord. It is the first application before the Central Administrative Tribunal. And compliance of that order, my lord, the rescind order is passed, speaking order is passed. Lordship. This date of dismissal, my lord,
17/6/14.
Dismissal by order dated 30/7/2007.
Oh. And what is 17/6/14?
17/6/14.
Date of demise.
Date of demise, my lord. 17/6/2014. He had died.
And then they approached for grant of pensionary benefits and compassionate appointment.
Yes. And by order dated 16/10/2015, the order is passed. And in compliance of that order, my lord, the speaking order is passed at page 131, starting from 130, 131, my lord.
So the order of the tribunal was ex parte.
No. On the basis of their application, starting from page 126, their application.
Obviously, on the basis of their application,
My lord,
You had appeared or you had not appeared. That's what we are asking.
no, no. My lord, it is a speaking order on the basis.
Is the tribunal's order of 16/10/25 passed in OA
Yes,
1551?
it's contested application,
It's a
contested order.
contested order.
Contested. 16/10/2015 is a contested order, my lord. This is related to earlier application. Oh.
Yes. Then what happened after
Then, my lord,
131?
speaking order is passed 131, my lord, challenging that order, my lord. Another application is preferred. And by an order dated 12/9/2019 at page, my lord. 97, my lord. Page 97. Perceive got it, my lord. Page 97. Since the removal order that was the subject matter of challenge in the earlier round and was not heard on merit, but has not been challenged in the present way, while the said removal order dated 30/7/2007 stands in way of the grant of compensation appointment or any other benefits, land council for the applicant sought for liberty to withdraw the present application to file afresh. Now, my lord, this application is filed and liberty sought for at page 93 to direct the respondent authority to set aside was the order of removal dated 30/7/2007 as passed against the husband while he was in hospital, etc. My lord. My lord, subject to correction, my lord. In the meantime, appeal order has been passed. So my conclusion is that both the orders should have been challenged, and also in the impugn order that has not been treated.
Page 93. What are you reading? Relief.
Yes, there is the relief they sought for, and that is the first page of the order. Those.
By that time, an order had been passed in appeal also.
Challenging the order, the impugned order is in past. This is the impugned order, my lord.
Why are you reading the relief? What is wrong with the relief?
My lord, relief is against only one order. That is the order of removal.
Therefore, we are asking you, in the meantime, an order had been passed in appeal also.
Yes, appeal has been passed, my lord.
Where is that order?
Yes. In pursuant to the earlier order, my lord, at page 130, 23/05/2016.
Page number?
At page 130, Lordship. And my lord, ordering portion is page 130. This is the appeal order. That should have been challenged also, my lord. This is my contention subject
How
to
is this an appeal? This is an order passed on the direction of the tribunal.
Lordship. This is the appeal, my lord. This is the appeal order.
It is not, sir.
My lord, if your lordship kindly comes to, my lord, the application made by themselves, 126, my lord. With due respect, I beg to submit this appeal with a detailed representation as ordered in this case under reference with also a direction, lordship, my lord.
That is not an appeal. That's not an appeal under CCS.
In that case, my lord, the appeal is pending.
So if they say it is a revision, it becomes a revision. It's not an appeal. That's an order passed in compliance of the CAT's order. There's no order passed by the appellate authority.
Then, my lord, still the appeal is, my lord, subject to correction, my lord.
Huh?
My lord, still the appeal is pending, my lord.
We don't know.
No,
we don't know.
Not filed, my lord.
We don't know whether appeal is pending.
No, not filed. Not
then
filed.
how are you saying it is still pending?
My pending, my due, my lord, due. It is not filed. If it is not an appeal, then, my lord, there is still no appeal, my lord.
So therefore, you are saying the tribunal's order is not sustainable because it did not direct them to go in appeal.
Lordship.
Very well. So even if an order is without complying with natural justice and there is no dispute on this point, the tribunal should relegate the authority to the person to appeal. and not exercise jurisdiction.
My lord, subject to correction, my lord, the statute, when the statutory provision is there for filing an appeal, my lord.
Correct. That is why we are asking you a statutory alternative remedy plea is available in when there is violation of natural justice and when the order is without jurisdiction.
My lord, this order
Is this-
impugn, my lord, is without jurisdiction as there is, my lord, statutory provision for appeal, my lord.
Sorry, nothing has to be done.
My lord,
What is
natural
the
justice,
direction?
my lord, CCS rules provides, my lord, service, my lord, it is at page 50.
And what is the ultimate direction by the tribunal?
My
To
lord,
consider as her claim.
was the impugn order of the removal from service and direct the respondent authority to consider the case of the applicant in accordance with the law, treating her husband as dying in harness and grant consequence release.
Yes.
My lord, this is a very sorrowful case. Actually, that incumbent.
No.
Appeal. That's it. That incumbent was commercial clerk once upon a time. And because of some psychiatric order, actually what happened, I don't know.
Why? How is that relevant? What happened to him? How is it relevant? Tell us, please.
But one point is this.
When he was appointed, whether he was suffering, not suffering.
This is a relevant matter.
A charge memo was issued, whether it was issued or not, start from there. Irrelevant things, why do you have to argue?
He was in hospital, my lord.
Yes.
Page 48.
No, they have not said that it was served. Why are you showing that?
Not served.
They have not,
Delivered.
They have not said that it
Not
was served.
delivered. And Dinanath Santara's case is very clear. Actually, regarding charge sheet and show cause notice, actual service must be required because
mere issuance is not certificate sufficient. There has to be actual service. Mere issuance is not sufficient. There has to be actual service. That
this
is the law.
Dinanath Santara case is very clear in this aspect, my lord.
Give us.
Very clear. Dinanath Santara. Already judgment আছে।
1998, 787, 5 Dinanath Santara.
Yes, this is a very settled proposition. So many judgments on this point.
My lord, Constitution 311(2) is very clear regarding hearing of the incumbent. And he was in hospital on that time. He was lying in the hospital. Even it had been served, he could not attend the inquiry. And he was 10 years in hospital, Luminipang Medical Hospital. And he has died thereafter in National Medical College on the very next day when he was come from Luminipang Hospital to National Medical College.
Your OA is there on record.
Even it had been served, he
You have said this in the OA. Have you pleaded this in the OA?
Yes, but yes.
Let us see.
Of this very
27 onward, my lord.
ওইটা দেখো ওইটা আমার পিটিশনটা
Yes, 4.4 and 4.5.
84
4.4 and 4.5.
certificate at page 40. Certificate at page 48.
The inquiry report is on record. Is the inquiry report on the record?
Inquiry report, page 20. Expert.
Neighborhood of charge sheet of say 49. ওটা তোমার এতেও আছে 49 এও আছে।
He is not a clerk, he is Chaukidar.
Yes.
Chaukidar, decategorized.
You said clerk, he is a Chaukidar.
Actually, initially appointed commercial clerk.
Whatever it may be, he is Chaukidar.
Decategorized to Chaukidar. That has been 44 recent number.
Inquiry report is at page 118. We are asking you, you are not telling us.
108, my lord, is the, my lord,
118.
yes, this is the speaking order, my lord. And next page is the,
This is of which date?
5,
5/9/2006.
yes.
Yes, that is the date.
The top of the letter, my lord.
That is the inquiry report. This is the inquiry report referred to in the first line of the order passed by the disciplinary authority. 5/9/2006. And where is the charge memo?
Memorandum of charge sheet, my lord, at page
108.
page 49, my lord. This is the memorandum of charge sheet. It is also again, my lord.
108.
Yes. The both pages.
Articles of charge bearer, yeah. Got it. 110. And his date of decategorization 22/2/2002. A5.
22/2002. That made him more psychiatric.
He has been made. And what is the basis for this decategorization?
My lord, medical.
Psychiatric.
Medical ground.
Medical means in many things, locomotive, medical, visually impaired. Did you file a
Page 47, lords, you can find the order of, my lord, medical decategorization for the post of commercial clerk and recommended by divisional.
You are reading the same order that we have read as A5 at page 106. We are asking you that this says medical decategorization for the post found medically decategorized. Medically is a very vast term.
But that is not under challenge, my lord.
Hmm?
But that is not under challenge. He never challenged, my lord.
Who is saying it has been challenged?
Lords, subject to correction.
Did you file a reply in the tribunal?
Lordship.
Where is your reply?
বলো কত কাগজের মধ্যে
Page 132.
132. My lord, annexure P8, page 132. Reply on behalf of the respondent.
Page
132, my lord.
That one. Maybe 2-3 paragraphs. Even if it is 2 pages, it takes long. In the OA, have you stated that it was on account of some mental condition that he was decategorized?
Wait. You know,
Page number 30.
Psychiatric ground.
883 4.4 এ বলেছি সাইকিয়াট্রিক গ্রাউন্ডে তাহলে 4.4
Psychiatric.
3 the applicant states that her husband decategory
Subsequently, he was admitted to notice for mental.
সেটা তো আছে পড়ে
For checking it.
যখন ডিকাটাইজ করলো না তার অর্ডার করেছিল
হ্যাঁ, সে order করে।
You granted 2/3 pension also.
compensate pension first after first order consider
After the High Court's order.
no
No,
I want
past
the tribunal
tribunal
order.
order.
First order. First order.
Order is passed, my lord, on the, my lord,
Order,
separate
order.
provision is there for, my lord, grant of compassionate allowance to railway servants who are removed or dismissed from service. There is a separate provision is there. On
Where is that grant order is there?
Yes, first.
131.
It is the grant order.
Approval was not was.
Grant order is there. That is my
Can we see the provision also? Oh, it is in the same speaking order.
that is speaking order is the matter grant order. Provision eta. But this is the separate provisions.
So is there any difference in the quantum of pension when it is under compassionate ground or the superannuation, or it is the same?
No, my lord.
The compensate pension.
There is a compassionate allowance, my lord. This has been given.
For 2/3 of pension. So you have found him to be deserving a special consideration.
My lord, that department.
I have found him to be deserving of special consideration. Yes, that's all.
That's all.
The present writ petitioner was the respondent before the tribunal.
My lord, direction was there in the honorable tribunal, but time is not specified, actually. Grateful.
In this. All the next case. In respect of Miller's item 8, Miller, I'm paying for some accommodation, Miller. Only Miller matter be taken up day after tomorrow. Miller.
In 8, in this matter,
Yes.
you are for the respondent.
I'm for
Tapal
respondent-
Mukherjee.
I'm for respondent number 4, 5, and 6. The the parent department.
This is WPST.
WPS. I'm
Day
for
after
parent
tomorrow, Miller, your lord.
Day after tomorrow.
Day after tomorrow.
So, 20 তারিখে please, sir.
19 তারিখ করতে হয়।
Against interim order.
I will satisfy your lordship.
But the order is only directly.
No, what is, it will take some time. Miller.
Not today, do it tomorrow.
Only Miller, day after tomorrow. Some difficulty tomorrow, Miller, just as Miller, day after tomorrow.
Not today, list tomorrow with a note, not today.
কালকেও থাকে, পরশুদিন থাকে।
Also, grateful, Miller, I'm grateful.
Item number 9.
My lord, in similar matter, my lord, your lordship, dragged the matter, my lord, kindly see. I am praying for regarding distributive pension in respect of Dharmveer Singh case, my lord. Same order, my lord, in respect of item number 9 and 11.
Ten.
10, my lord, I am appealing for the petition.
Yes.
হ্যাঁ, আপনি 10 তো হ্যাঁ 10 my lord, here I am appointed as a ANM in the year 1990, and from 1990 my lord till date, my lord, I am working as ANM, and from my lord to December 2023 I have not been paid any salary, and my lord, my salary has been stopped by the authority concerned from December 2023. I made several representation. I filed application before the tribunal, and my lord, if your lordship kindly says the rejection, the ground of the rejection of my tribunal application, that is if your lordship kindly come page 93. Tomorrow. My lord, instead of tomorrow, my lord, day after tomorrow. No. আবার কালকে বলে এতগুলো ঝামেলা হয়ে গেল।
11, my lord, similar order like item number 9, my lord.
Lord, the lordship kindly.
Respondent, service has been effected, my lord. We again inform by speed post, my lord.
My lord, with regard to item number 12 is concerned, my lord, can it be day after tomorrow, my lord? Beseeching your lordship, my lord. Although it's not the time, my lord, item number 12, day after tomorrow, my lord. As a lordship, I will be here, my lord.
ডাউনলোড করতে পেরেছেন?